And the other was something that some of the clients are asking for, but their opinions are kind of what I so I don't have that. What I'm anticipating is that otherwise.
It's we have this just take the yeah, but like I mean, that's the official. Yeah, I started that. But you know.
We got time, no.
Okay, we're gonna go ahead and call our meeting to order. It's 4 o'clock and we'll start with the Pledge of Allegiance.
So I got
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Lori, could you take the roll, please?
Christopher Abel.
Here.
Keith Hansen.
Here.
Matthew Phipps.
Present.
Stacy Selder.
Here.
Matthew Spalding.
Here.
Carrie Trask.
Here.
Tony Vestelka.
Here.
Okay, hi Bob. Want to just introduce yourself to the board?
Sure,
And
I will. Thank you very much, Stacy. I'm Bob Butler, Staff Counsel and Associate Executive Director of the School Board Association. And I've had the privilege of working with school boards and school administrators and staff since 1990. And first off, I want to thank you for the invitation and also for the service that you do for your communities, your students and your staff, taxpayers, and hopefully here to help today. So we'll see what we can help with. And we'll start with that, Stacy, and then see what kind of direction you would like.
okay, great. So I know we posed some questions to you.
Correct.
And I don't know if you want to start there or maybe a little background or,
I can dive into the questions because I think they were very broad in scope.
okay,
Right, and I purposely didn't bring a handout. I have materials, and then afterwards, if you want to see any of it, you can. But I wanted to have more of a facilitated conversation because when I work with issues around the First Amendment, Title IX, non-discrimination issues, there are certain things where the law is very clear and the law has explicit directions. There's areas where the law is gray. And in those gray areas, they're very fact specific as to what you may choose to do. Some of that is dependent upon your various risk assessments and how you balancing risks, or how you're accommodating individuals and individual versus a group as a whole. And then obviously what community standards are, where your community lies on a particular issue. So I try to come in and say, this is where we think the law is pretty clear. Where it isn't, we will go through that assessment, but like I said, it's very fact specific, but obviously there could be variations. So I know in some of your conversations you'd have or some local policy development, there isn't necessarily a one size fits all on a lot of these topics. And so that's what I want to convey to you, areas where we think that either the courts or the statutes are clear, and areas where we do not think they are clear. And therefore, you're going to have to make some policy calls as the elected officials and as the administrators as part of the leadership team.
So I say dive into the questions.
Okay, well, the first one was pretty basic in one respect, and in another respect was pretty broad. It said, what is Title IX? And Title IX is the educational amendments from 1972. So it's been around for a while. Just curiously, what do you hear when you hear Title IX? What did you hear or think of when you heard Title IX for decades? What came to mind? Women's sports, right. I mean, that was what it was like. Okay, Title IX, we're going to look at girls softball vis-a-vis boys baseball and see what the resources are, or what are the opportunities for female athletes. But it was way beyond that. Even when it first went in, it's a very simple sentence, and I'll read to you. It says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So that's the core of the law right there. And it has really not been modified too much through the years through statutes. It has been modified through regulations. We could touch upon that in a bit. And it's obviously been modified in how courts have interpreted it through the years as well. When it first went into effect, it was thinking about athletics. It was thinking about breaking down stereotypes and barriers in educational programming. So the young woman who wanted to be in shop class or do auto body work. But it also covered the young man who maybe wanted to go into family and consumer ed in a different area that was also breaking stereotypes in another way. So it covers both males and females, and it always has. It's also addressed things like gender nonconformity. In 1972, when it went into effect, again, the gender nonconformity was more along the lines of the girl taking shop class or the guy, wanting to learn how to sew. It was that kind of thing of you can't be discriminated against in your opportunities into that. Whether it was barriers in STEM fields or whatever it happened to be, that was the genesis of it. When it was passed, Congress directed the federal agencies to come up with regulations. That was the Department of Education. Those regulations have varied through the years, but they generally were on those educational programs and activities, but they also covered areas where someone may have been sexually harassed based on their gender. So if that young woman went into the auto body shop and then was being sexually harassed, well, that was denying her the ability to take auto body shop, right? And so the law got interpreted to say that's prohibited. And the law gradually changed throughout the years. One of the more significant events that happened, and it was during the Obama administration, when the Department of Education put out regulations that covered gender identity and sexual orientation. And so that was an expansion of some of the interpretations of Title IX that had existed prior to that period of time. When the Trump administration came in, they rescinded some of that guidance. However, they still said that you can't discriminate on the basis of sexual orientation or gender identity. And right toward the end of the Trump administration term, they put out regulations on sexual harassment and sexual assault that were pretty significant, right? And we still are living underneath those today. Those are still in effect. And what those required was that you had to set up a grievance process for handling sexual harassment complaints. And it basically looked at it saying that you're not prejudging a sexual harassment complaint to say that either the person complaining, the complainant, was more credible than the person being accused, the respondent. And so when that went into effect, districts had to adopt policies, and you have one. You have a policy in your district that addresses when a complaint comes in on sexual harassment, for example. And that procedure for handling sexual harassment complaints or complaints with respect to sexual assault is separate and distinct from policies and procedures that you'd have for other protected classes, like race, religion, disability, etc. Right now, the Biden administration has proposed modifications to those regulations that presently exist. One, they would change some of the definitions of what constitutes sexual harassment. They would empower the Title IX coordinator to make recommendations for discipline, which right now the Title IX coordinator doesn't have that ability. And they also somewhat reinstate some of those Obama administration guidance documents and put them into regulations on how students are treated with respect to gender identity, an expansion of gender nonconformity in those areas. Those have not been implemented yet. We don't know when they'll be implemented, but it could be very soon. It's hard to know specifically where they are. That regulatory process, I'll get into that a bit because I think there's a separate question on it. So that's just a real quick and dirty view of Title IX. Now, Title IX is not the only area in which districts face these issues of making sure that the educational programming that you have isn't discriminatory in how it's being implemented for students and or how staff implement it, make sure it's done in a non-discriminatory manner. We have Title VI, and these are all federal, the ones I've gone through right now. So Title VI, that deals with race and national origin. It has a different process for implementing claims if someone says they're being discriminated on that basis. We also have the Individuals with Disabilities in Education Act, so it's for special needs students. We have the Americans with Disabilities Act for employees. And we have Section 504, again, for students with disabilities who aren't part of an individual educational program. We also get First Amendment issues. First Amendment with respect to accommodating students' religious beliefs. Those also come up in the discrimination realm. But those are the main ones at the federal level. And there's others that I've been just not covering every single one of them at the present time, but that's the bulk of the ones that we get issues on. There are also state laws on it. There's a pupil non-discrimination statute, Chapter 118, that says all these prohibited basic or protected classes for discrimination underneath state law. And then there's an administrative code, and this becomes somewhat confusing. So let's say right now, we have Title IX for sex discrimination at the federal level, and then we have what you'll hear is PI 9 for state non-discrimination in the administrative code. That stands for Public Instruction Code Number 9. And that's much more expansive. So that'll cover everything, again, from disability, religion, race, national origin, creed, etc. will be underneath that. But that's a state law. And that one, individuals can file complaints if they feel their education is being impaired and they're being discriminated against on the basis of one of those protected classes through your policies. So your 2260 policy encompasses what's underneath that PI 9 in addition to some of those federal laws I referenced. But they can also file a complaint with the Department of Public Instruction on those areas if they so choose to go that route, or go to court. And individuals go to court on these issues from time to time. On the federal side, if the individual has a concern and they've gone through your internal processes, they could file a complaint with the Office of Civil Rights. And our office is in Chicago, our regional office is in Chicago. They can file a complaint with them. They could also go to court and try to argue either Title IX or an equal protection claim underneath the 14th Amendment. And that basically says that the government's not going to treat someone differently without a compelling governmental interest on the basis of some protected class status. So that's a real quick overview, but I know, Stacy, those were some of the questions on that. So I don't know if real quick there's anything on that piece before I get into the next question that was asked. Okay, so the next one was, how can we write a policy that protects everyone? So, obviously when we say everyone, we're looking at it primarily from a standpoint of balancing all those interests. So there are some times where there's a friction between accommodating one person who, let's say, has a Title IX concern on gender, and someone else who may have a religious creed issue underneath state or federal law. So as I mentioned, underneath state law, we have that pupil non-discrimination statute in section 118 of the statutes. And that requires you to adopt written policies prohibiting student discrimination. So you have that. And I know you're a Neola subscriber, so they've sent you your pupil non-discrimination policies, and those, the intent of those policies is to make sure you're complying with that state law. When you do that, underneath that state law, so again, that PI 9, you have to adopt those policies and procedures where you designate an employee to receive complaints, which your policy does, and you establish a procedure for receiving and resolving those complaints, which again, your policy and your procedures do. And it comes into particular people who are identified, their names and addresses are listed down. The complaint comes in, and then they investigate it. Now, there may be some circumstances that that individual might have a conflict of interest or feels they can't be impartial, and you have to bring in someone from the outside, or there's some other designee that either Jim or the board comes together and says this is the individual who's going to process that particular complaint. But the policy has to have that procedure, or has to have those items in it. It also has to have something that the individual filing the complaint is notified of the policy and the procedure. That's typically done by giving them a copy of it. You know, in your policy describes that. I then thereafter has to say that they have the ability to appeal that up. So someone does the investigation, there's a decision, and then there's some process for the appeal. And that appeal process underneath PI 9 may look different than what it is underneath Title 9. Title 9, the roles have to be extremely segregated. You have Title 9 coordinator or outside investigator investigate. They cannot make suggestions for penalties. They can merely say, I feel the policy was violated, or I felt it wasn't, right? Or the law was violated or wasn't. And then there is someone appointed to be a decision maker. And that individual then looks at the report and then says, yes, there was discrimination. We're going to suspend the pupil for X number of days. Or no, there wasn't. And we find the respondent was not culpable for whatever these allegations are. And then the party can appeal that up to another layer underneath Title 9. State law doesn't have that same segregation of things. So when these complaints come in, they can be really complicated because you can have converging laws at state and federal level, and you can have certain situations where it doesn't rise to the level of unlawful behavior, but you still don't want it to happen, right? And it could be bullying, or it could just be, it was inappropriate language in the classroom. I'm not going to call it sexual harassment, but you shouldn't be using those words in the classroom. You violated the classroom's rules of decorum, so to speak. There's also a discrimination process in state law and underneath federal that's separate and distinct for students with disabilities. You know, if they feel their IEP, their individual educational plan, is not being followed. Underneath the Title IX, as I mentioned, there's obligations to publish and make sure people know what those procedures are, which you have done. You have those up for. And you have to, for all of the laws, designate at least one person to be the intake for the complaints. Title IX, again, that's a little bit more detail for who the individual takes the complaints. And generally, we recommend you have a minimum of 2 individuals, and they be of opposite genders. So a male student may be more comfortable bringing the complaint to a male Title IX coordinator, or vice versa. A female student might be female, a Title IX coordinator, but that's not required. You know, it's just, but it's generally a good practice to have more than one individual. So the short answer is both laws require to have, both state and federal laws require to have a policy and a procedure and some way to notify people of those requirements. And you know, you have that in your incumbent policies that it's for anybody to see. Any questions on that? The next question I got was, what can we add to policy to navigate these situations? Well, you have the policies and the procedures. What I find as a practitioner in the area is having training for the staff so that they understand the gamut of what their responsibilities are underneath these laws. Because again, they are separate and distinct depending upon the facts of the complaint and what protected class may be triggered. And then also having within that, beyond the training, a reminder I always give to people when I talk to clients about this is, my role as an investigator is not a prosecutor. Right? So the person investigating, their role is to be a fact finder and figure out what occurred and then judge the merits as to was there a violation of policy or any of the state or federal law. And that's important to notify everybody. And if I felt I was biased toward the complainant or the respondent, I shouldn't be the one doing the investigation. I should have somebody else do that so we know they're impartial. So those are the two things I see is the training for people to come in and then realizing I'm not in a prosecutorial role. And then the third thing would be what I alluded to earlier, that just because something may not rise to the level of sexual harassment doesn't mean that we want to condone that behavior. And on the flip side, even if something may make someone uncomfortable, that doesn't mean it's disciplinary. It could be protected student speech, or it could be protected employee speech underneath the First Amendment. So you're grappling with all of these facts at the same time. So any questions on that one? All right, the next one I got as a question is it against the law to not add gender identity to the classification? This was in reference to your 2260 policy as to the protected classes. Is that accurate? Yep. Yeah, okay. There isn't something in the laws that say that you must add that in, all right? That you have to add that into the list of protected classes. Some districts choose to do it. Some districts don't. Some districts have viewed it as well. We kept the word sex in there and we interpret that to include gender nonconformity, identity, because that's where the courts may be on the issue. And I'm going to break that court issue down and differentiate between employment and student issues as well. So there's nothing that explicitly says that gender identity must be added. Underneath state law, sexual orientation is covered by that state law on pupil non-discrimination. So sexual orientation is something that's required to be there underneath state law. It's not in the federal law itself. And the federal law, it's been coming out more through court decisions that I'll talk about in a bit. For employment, you may be aware that in 2020, there was a court decision called Bostock versus Clayton County in Georgia. And the United States Supreme Court held that Title VII, right? So I'm going to toss a lot of titles around here, okay? But Title VII is the federal law that prohibits employment discrimination on the basis of sex. That was originally passed in 1964. So it's a part of the civil rights era legislation that came out to prohibit racial discrimination. Sex discrimination was added in at the same time. Through the years, courts and federal agencies like the Equal Employment Opportunity Commission have interpreted that word sex and tried to decide what does that mean. Well, in 2020, a case got before the United States Supreme Court. And in an opinion written by Justice Gorsuch, the U.S. Supreme Court held that Title VII's prohibition on sex discrimination covers sexual orientation and gender identity. So for employees, the law of the land, because of the Supreme Court decision, is if I applied for a job and I identified as a different gender, the district could not take that into account in my hiring process. Now, you still might have some situations where because of real privacy interests, like girls' locker room or something, you might view that. But otherwise, you couldn't say I can't be the Phi Ed teacher because I identified as a female, for example. Federal law would prohibit that in employment. So why that is relevant is because your policies like the 2260, bleed together student and student rights and employee rights. So when I get the question about what does the policy require, well, right now we have the Supreme Court decision that says gender identity and sexual orientation are covered underneath Title VII of the Civil Rights Act. That's employment. Then when we get onto the student issues, what's happened through the decades with these areas is when something happens in employment law, on the student side, to a degree, the courts, they don't automatically grab that, but they often look at that. And that has happened recently with the courts that have viewed some of these issues with respect to sexual orientation, gender identity, et cetera. Now, sexual orientation, I'm going to kind of leave on the sidelines because, as I mentioned, state law prohibits discrimination on the basis of that for a student and in employment, right? So that's, legislature passed those. They were signed by the governors at the respective times. That's on the books. For students, that has either come through the regulations or the guidance documents, like the Obama administration guidance documents, the proposed Biden administration regulations, again, I say proposed because they're not in effect yet, or court decisions. And so in the guidance area, when the Office of Civil Rights comes out, whether it was in Biden administration, Trump administration, Obama administration, and they say that, yes, it covers gender identity, they may interpret that differently as to what the breadth of rights are there, though, right? But they say it covers, Title IX does, for example. When the courts have viewed this, the courts have viewed them on very fact-specific items. And there is a split in the circuit courts, Court of Appeals in the country. So there are 4, I believe, maybe more, but there are at least 4 Federal Court of Appeals. The most important one to you is the one that controls you, which is the 7th Circuit Court of Appeals, which has addressed whether Title IX, federal Title IX, covers gender identity. And the Federal Court of Appeals that covers us has said that it does. All right, so they start with that. Yes, it does, as does the 14th Amendment of the Constitution with the Equal Protection Clause. The 11th Circuit Court of Appeals has said, no, it's there, but it doesn't mean that you have to afford, let's say, a student who is assigned the gender of male at birth. So he's boy, and now he identifies as a she. You don't have to give them the right to use the restroom. The 11th Circuit Court of Appeals said you could have restrooms that only biological males can use the men's restroom and only biological females can use the female restroom. The 7th Circuit Court of Appeals, the 4th Circuit Court of Appeals, the 2nd, have come to the conclusion that with specific fact patterns, that the student can use the restroom of the gender they identify. So at one point, we thought, well, the Supreme Court will take a case up. So the most recent case in our jurisdiction that was this past summer involved a school district in Indiana. And the 7th Circuit Court of Appeals sided with the plaintiffs in 2 different school districts that those students who identified with the gender different than the one they were born in could use the restroom, right? And they could use the restroom of the one that they identified with. The school district filed an appeal up to the U.S. Supreme Court. The U.S. Supreme Court declined to hear the case. So that just happened in January, all right? Which in one respect, a little surprised by, because you have this 11th Circuit saying you can have the segregated restrooms, and the 7th Circuit has said you can have segregated restrooms, but if the student wants to use the one they identify, they can. And so you thought, well, you got this conflict here. Maybe the Supreme Court will come in and say once and for all, this is what it is. They declined to hear it. So when they declined, it's called, they declined to give cert, to basically review. So that's the case that's covering us. Now, when it covers us, if you were to look at the decisions, and the decisions are the case called Martinsville, AC versus Martinsville. What's interesting in the decision is they go at great length to talk about the facts of those kids. So you had kids who had medical diagnoses for gender dysphoria. They had parental support. They'd been identifying this way for a long period of time. So one could say, well, with that fact pattern, maybe that's different than someone who very recently does it or the parent doesn't consent, right? At the same time, they go to great pains to describe the facts and the parents are on board here, et cetera, et cetera. At the same time, then they made very sweeping comments that Title IX covers gender identity. Right? So from you as a policy decision maker, where I have found districts in the last year, 2 years, 3 years, struggling to navigate these issues, restrooms, locker rooms, athletics, instructional curriculum materials, and then parental engagement, parental involvement, parental sign-off. Okay. And in some of those areas, the court cases, like on the parent issue, at least the one that's binding on you, doesn't address it. Because it's assumed in those cases that the parents are fully behind this situation. There was a case out of the Kettle Moraine School District, so down in Waukesha County, that solely involved Kettle Moraine and its policies, where the Waukesha Circuit Court judge said the parent had to approve the gender identification of the minor child. So it's not 18, under age 18, both for names, restroom usage, utilization, etc. That case is not binding on anybody other than Kettle Moraine and the student and family in that situation. So where that puts you policy-wise is where I've had districts address these issues is both, like I said, in the name issue, the parental consent to these various things. How is the parent brought in to these kind of conversations of the child identifying? And then the other piece of it, which some of your questions got to, what about the other students that are potentially either directly or indirectly impacted by the child we're talking about, it's their change in gender identification. So there's definitely, as I mentioned in the very beginning, there's certain things in the law that I can say are relatively clear. Things that are somewhat unclear right now are some of those issues about what's the parental say in this matter. And as I said, school boards have generally, in my experience, been, I'd say, particularly under the age of 14, very much on the side of parental consent and involvement. 14 to 17 becomes a little bit shakier in some respects, because in that age bracket, for like medical information, most of the time the parent has the sign-off rights, but not universal. Students, when they get to be the age of 14, they can legally go and get their name changed even without their parents' consent in Wisconsin. But most of the time, these things aren't legal name changes. They're someone just preferring to go by a different name or pronoun or something. And then age 18, the 18-year-old can pretty much decide what they want to do because they're an adult. So that's a brief piece as to back to that original question as to, does the policy have to have gender identity? It's not distinctly against the law not to have it in there. There was an Office of Civil Rights resolution case. And what that is, just so people understand what it is, it's not binding on anybody other than the school district that signed off on it. It's not a court decision. What it is someone files a discrimination complaint against a school district, and instead of it going to court, the school district and the Office of Civil Rights at the federal level come together and they reach an agreement as to what they're going to do going forward. And it came out of Forsyth County in Georgia. And what happened in that case was the school district at board meetings was looking at instructional materials, and people wanted certain materials pulled from the library or not in the curriculum. And when they did it, people who were advocating for some of those items to be pulled, they made comments justifying why they wanted it pulled. Students in the LGBTQ community said that those statements made them feel like they were in a hostile learning environment. So they filed a complaint. And even though the board members, the administration, none of them were the ones that made the comments, the Office of Civil Rights said, well, the district didn't take effective steps to make sure those kids were in a safe learning environment. And so then they had to go through and do training and offer resources to those students who were there and basically caught up in the maelstrom around the comments that outside parties had. And the reason why I bring that forward is when controversials come forward, there are sometimes like collateral issues that you don't think of right away. You know, you're like, when I'm telling you here, the policy doesn't have it in. If legally, if I say, well, you don't have to have it in, you choose not to have it in, that's your call, right? If people make comments that then suddenly a segment of the student population feels that it's not a safe learning environment, there may be other issues that come up about that. So when we've had issues, whether it's on name changes, pronouns, et cetera, I've had districts proactively explain the rationale to students who might be affected for it as to what it is. So let's say the rationale was, we want parental consent and parental involvement. We want the parent to be involved. This is not about your sexual orientation or your gender identity. This is about parental involvement. And we have parental involvement in all these other areas, and we're going to continue to have it over here. You know, we're not going to allow you to make these major life decisions on your own when you're a minor, you know, without the parent being on it. Again, local communities may view that continuum differently, but that's been the rationale of the districts who went down that route to have, I don't say more parental, just like maybe reinforcing the parent's role in that, so that parents aren't surprised if they show up at a parent-teacher conference and someone's being referred to by a different name, and or if word comes back to them indirectly that the kid's identifying differently at school and they didn't know. And that's what that Kettle Moraine case was about. You know, the parents didn't have notification, and that circuit court judge said, no, that is an integral part of raising the child. The parent doesn't give up that right just because they send the kid to school during the day. You know, that was that judgment in that case. So you can see some of these are, you know, they're difficult questions for you to navigate as you go through that. But short answer again, not against the law to not have gender identity included. If districts who include it, those who choose not to. Those who include it for employment, they don't include it for students. But for now, as far as what is the controlling law, and the law will say that you can't discriminate on that basis in either direction, but then you get into the, okay, well, what is discrimination, right? So when we talk about like the pronoun use or the name change, is it discrimination or not to require parental consent? I don't have a case on that I can say to you, yeah, the court said it is, or the court said it isn't. It's an open issue for right now. Other than that Waukesha County one I mentioned that, again, it's not binding.
So
Anyway.
I want to know clearly, like,
Yeah.
what the liability would be for the policymakers to leave it out.
I don't see there's a liability in and of itself for leaving it out.
Okay.
Why I brought up the Forsyth County case was, what the Office of Civil Rights did there was, they didn't come in and say, school board and administration, you should leave these books in the library. You can't pull the books out. But like, you were fine doing whatever you wanted to do with the library. You didn't violate the law doing the library. Your violation was more indirect because people came at the meetings and made comments that then the OCR felt credible that impacted the learning environment of the protected class students.
Right.
And so the liability was more there, not in the decision. And so if the decisions, if let's say the people had come up and it just said, like I was talking to a district about this the other day, and it was, our issue is not gender identity, sexual orientation. It is the explicitness of the sexual content, irrespective of orientation, identity, anything. We just don't think it's age appropriate for that material at that age. And that was the categorization. I don't think you'd have any liability whatsoever in that, right? I mean, that's just, okay, that's our standard on it. You might get into some First Amendment issues about, is it truly offensive or not, those kind of issues, or does it have some other component? Where the liability would come is from somebody saying, I was denied some educational opportunities because of this. So for right now, let's say, for example, because of the court decisions we have, and the US Supreme Court declining to hear the case, if you had someone who had identified as a gender different than they were born as, and they wanted to use a restroom, and they had parental consent, and they've got medical documentation, if necessary, and and the district said, no, you can't use that restroom, then your liability carrier might say, we're not sure if we're going to cover you on this because this case is clear. All right. Now, whenever those happen, districts can always look and say, yeah, but our facts are a little different. All right. So I don't have parental consent. The kid doesn't have any medical thing, and they just went into that bathroom today for the first time and something bad happened. Right. That is a different fact pattern. And so liability can vary depending upon the core facts of this. But I always encourage districts, you have liability insurance. So beyond contacting your own legal counsel, you contact your liability carrier. And you don't make decisions solely because the attorney says one thing or the other, or the liability carrier says something, but at least you go in with eyes wide open as to what your potential risk is on something. So we've had districts, let's say, who really wanted to emphasize the parent's role in this. And I'm not talking about parent role in those very isolated circumstances where the child shares with the counselor that the parent hit them or something. And I tell districts, if someone comes in and says, dad hit me because he doesn't want me to identify a different gender, that gets reported to Child Protective Services just like it would if it was like, dad hit me because I was wearing a Minnesota Vikings jersey. And I'm not trying to make light of the significance of gender identity versus being a Vikings fan, but it's just like you have a reporting requirement regardless, but you shouldn't make the assumption right away that withholding the information from the parent is needed from a legal standpoint. It's rare circumstances that it would be legally required. Like we've gone through this with counselors. Counselors have a creed that says that they keep things confidential. The difficulty is that creed is not a law. In our state law, we have a specific law that says really what they're not allowed to share is like drug and alcohol information if the kid comes and talks to you about it. But I don't have a statute that says if a kid comes in and tells a counselor, I feel like I'm female, that isn't shared. Now, if the kid says, I think I feel like I'm female and my dad hit me when he saw me, well, she's got a reporting requirement, right? The counselor does. But otherwise, we're going to bring the team together and say, how are we going to work with this? Because practically speaking, the family's going to find out at some point, right? And the worst fact patterns for me that I deal with have been the ones where the parents feel that the district withheld information from them. And I don't have too many circumstances where people, that's where I think some of your liability comes up. That was the Kettle Moraine case. That was the
Yeah. I'm looking at the current Title IX and the current PI 9, and I don't see in there anything that says gender identity, but I do see sexual orientation. Am I correct?
You are correct.
In saying, well, okay, am I incorrect in saying before the way that we kind of summed up a lot of roundabout what you were talking about, that includes the gender identity? And if that's correct, then does adding that verbiage into the policy, is that not redundant?
You are, I'll break that down in two parts. One, whether you put those two words in there or not. Right now, I say right now because the student side and the employee side on gender identity, not on sexual orientation, they're court decisions. So just like we saw that split between the 11th Circuit and the 7th Circuit Court of Appeals, it's possible maybe someday the Supreme Court takes it and they give a different interpretation. So that is not mandated in it. Sexual orientation, you're correct, is under state law. So whether you put it in there or not will not really affect your obligation to provide services, et cetera. Now, when districts choose to do it, they're doing it for reasons for either clarity or endorsement of that viewpoint. When others choose not to, they are viewing it for, well, We are only putting in what the statute says we must do. All right, that's all we're putting in. They're both valid choices. You figure it out between yourselves as to what you want to do. And like I said, I have districts who do it both ways on the topic. It doesn't mean if a situation happened, let's say like the name change, that they may not be approaching it and addressing the issue exactly the same. Or if the kid was being harassed based on his gender identity, that they're not responding to it the same way. It doesn't matter whether those two words are in there or not from a legal standpoint. It may, from again, optics in either direction, that people have viewpoints on this.
Okay, and then the part where is that essentially, is that covered under the term, under the definition, sexual orientation?
A gender identity is not underneath the sexual orientation. It's only just the word sex.
That's what I wanted to.
When I read that sentence, you saw how narrow it was, right?
Correct.
So it's a very narrow sentence. But through the years, gender nonconformity got covered. And that's kind of how the courts went through the years on this of, well,
It's pretty vague.
yeah, it was a vague term and it's been interpreted. And why I brought up the employment piece was when the Civil Rights Act passed in 1964, it didn't cover sexual harassment. It was just, was Jane Doe not offered the job because she was female? And then as the years went by, courts looked at it and said, well, Jane Doe's being harassed at work. We're not talking about having a bad boss. We're talking about either quid pro quo harassment. You have sex with me, you'll get the promotion,
Right.
or the workplace environment. And so they said, well, Jane Doe's only being treated this way because of her gender. She's a woman. So we interpret sex to include sexual harassment. So then we get that over into the education sphere too with students. And so there's been this evolution over the last 60 years on the employment side. And we see a similar thing on the student side.
I just seen, and the reason why I asked that, because I've seen in there, at least in the PI 9, that it defines sexual orientation as what the way it defines it in 11132, which doesn't have that in there either way.
That's correct. Okay, right. No, you're absolutely right. Gender identity is not covered under the state law on pupil discrimination or on the employment law.
Any aspect.
It's not listed anywhere, and it's not listed in the federal law either. It's not, those two words are not in it. It doesn't mean, again, regulations, different story. Other questions on that? No, one of the questions I got was, what's the constitutional process to create or pass a law in the United States? Well, basically, in order to pass the legislation, each House of Congress has to pass it. They have to pass the exact same verbiage. It goes to the president for the signature. If the president refuses to sign it or vetoes it, then each chamber has to have at least 2/3 of a voting measure to override that. And then a question was that followed in adding gender identity language to Title IX? Title IX was passed and signed by President Nixon in 1972, so that process was followed for that. But just as a follow-up to your question, gender identity was not part of the past legislation. It's court interpretation and regulation. The next
Question. Wouldn't that be, it sounds to me like a lot of what you've been talking about has been court interpretations since then. Is that a fair?
Yes, there's a lot of court interpretations. There's also agency interpretation. So you had, I'll just use the Department of Education as an example, and how it changes from era to era. And some of this it's a really fresh topic because the U.S. Supreme Court just heard some oral arguments on the role of an agency in crafting regulations a week or two ago. But basically, these items either get reviewed by the courts and a court comes out and says, yes, Title IX covers gender identity, or they do it, like the first case we had in our jurisdiction was a case called Whitaker out of the Neosho Unified School District. And they addressed that on both Title IX and the Equal Protection Clause of the 14th Amendment. That was a restroom utilization case for a student that was transgender. So the court decided that. The Seventh Circuit Court of Appeals decided that. You could also have regulations where when Congress passes the law, they then say this agency has oversight for it. So the Department of Education at the federal level has oversight. Their subdivision or subunit, the Office of Civil Rights, enforces it. And so there can be guidance documents that basically say this is what we think the law looks like. Those aren't binding. Those are just, and they change from administration to administration, right? So when Betsy DeVos head up the Department of Education, she rescinded a bunch of the guidance documents from the Obama administration on these topics and just said, you know what? We're just following the regulations. If it's not a regulation, we're not going to put out a guidance document to tell you how to do this, right? Because the guidance document, as an attorney, if Jim calls me and I'd say, there's no statute, there's no reg, but they said this is what they mean. So to give you a different topic, you may have heard one of us or at some time, maybe Jim or someone else on the leadership team said, well, there's an attorney general's opinion that says we should do X, Y, or Z for the open meetings law. It's just an opinion. They wrote a letter. It's not binding on you. The benefit it has for the district, that's using the attorney general's opinion, is if I relied upon it, a judge is more likely going to cut me some slack liability-wise, right? But it doesn't mean that it's binding on me. So during the Trump administration, they rescinded a lot of those guidance documents, and they put in their new regs, their new regulations. And so you had those. Now, the Biden administration issued both guidance documents saying, we believe Title IX covers gender identity, and the Department of Justice did something similar. Right? So you have the two federal agencies telling you that. And then the Biden administration puts out new regulations on Title IX that have gone through a process of they're drafted, there's a public comment period, they digest those public comments, and then they decide whether to issue the new regs or not. And so some of the flashpoint topics like we've been talking about on gender identity, with restrooms, names, athletic participation, those, the first two are addressed in the regulations. The second one's a whole standalone. The whole athletics is treated completely differently. But the short answer to your question is a lot of this comes out of court decisions and regulations. And that's why there's some court decisions that are very straightforward. And when the justices, either at the Supreme Court level or Court of Appeals, write it, I can say, they said X. So let's say, for example, again, public records law. The Wisconsin Supreme Court says, this is how you handle personal emails that are used on a district's email server. As it relates to governmental business, it doesn't matter whether I use my personal email address, or the district one. It's related to governmental business, public record, and then we go deciding whether it's going to get turned over or not. Very black and white. In the issues we're talking about, from a practitioner standpoint, what's sometimes frustrating is they will go through and describe all the facts and then say, based on these facts, we conclude this, and then give a very broad sweeping statement.
They can do
So the two are juxtaposed against each other. And then, or they'll say, the question was also raised, what do we do about this topic? Well, those facts weren't before, so we didn't answer. So then you just have to wait till, okay, when do those facts arise? So for example, we haven't had it in our circuit, but there was a case out of Connecticut with athletic participation, or transgender female athlete participating in a state track meet, and cisgender females filed suit against their version of the WIA, saying that that individual athlete shouldn't have been able to participate because she won some events. Right? I'll just finish this thought linkage. So their case was the cisgender athletes lost their case by 2-1 by the Court of Appeals there, and because they basically said you're unable to prove an injury to us. Well, now the full circuit of the Second Circuit Court of Appeals is now hearing the case. So maybe they're going to affirm what the three justices said, or maybe they're going to come out and say, no, at some point the facts can be such where the transgender female's participation deprives the cisgender female some opportunities and access to programming. Yeah, but they're so fact specific when you
So
get,
does statute trump opinions on regulations?
the statutes, the regulation can't be counter to it. Right, so.
Yeah, okay.
So I can't put a regulate, if the statute says you can't discriminate on the basis of sex, I can't put in a regulation that says, yeah, go ahead and discriminate.
Yeah,
Can't do
okay,
that.
yeah, okay.
What gets into it is that gray area of how much did you expand this from what it was, or does the regulation, does it conflict with a prior court decision? So when they.
But can a statute, just neutralize a court opinion? It can't.
It depends on when it was done. So if the law is written now, like this one, in the Seventh Circuit Court of Appeals comes in and says, we interpret sex to mean gender identity, then I'm following the court. If they pass a new law afterwards, the federal government did, and it said, no, it's not covered, now they basically told the court, you can't do it on Title IX, because we said Title IX doesn't cover it. But when the courts have done these, they have very often said Title IX, which is the statute, and then they latch on to the 14th Amendment Equal Protection Clause, which is constitutional.
Okay,
All right, so you have, but not always.
that's why there's so many lawyers,
Yeah.
Yeah, this kind of ties into what you were just talking about. I kind of want to dive into, thank you for all the foresight, or the kind of the process of complaints and the system, how it works. And listening to all that, I hear that pretty much in the arbitration, you said, there's males and females. Is there any case law or things that you know in the query that have added a third class of a human being, that there's males, females, and something else? Or has it only been males and females?
I'm sorry, I'm not tracking the question.
Well, the question is, do you know of anything in case law that's trying to perceive that there is more than just males and females?
I'd have to go back and read the Gorsuch decision, or Neil Gorsuch decision on Bostock. I butchered it here. To see how in-depth they went into gender identity as to whether they used the term non-binary or not. All right, I don't know off the top of my head. I just know and that's employment. Yeah, an employment side, because an employment side, they basically, I can quote from it, so I'm not paraphrasing what they said, but the general sense of it was, if the employer, so they gave the example of an employer with two employees, both of whom are attracted to men. So, well, that was the sexual orientation. We don't need to get through that one. So he gave an example of, provide an example of singling out transgender individuals as discrimination on the basis of sex. Take an employer who fires a transgender person who was identified as a male at birth, but who now identifies as a female. If the employer retains an otherwise identical employee who is identified as female at birth, the employer intentionally penalizes the person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. Again, the individual's employee's sex plays an unmistakable and impermissible role in the discharge decision. So that's what the Gorsuch opinion says in that Bostock case. I'd have to go through and see if they gave an example of non-binary or not. But they basically were saying that if you tolerate the behavior in one gender and you don't in another, and there's not some business necessity for it, then you're discriminating on the basis of the gender nonconformity. But again, I just don't know if the court has done that. Sorry. Other questions on that one?
I have a follow-up question. I mean, is it reasonable, just hearing you explain, the origin of Title IX and then really, what it's evolved into today, and knowing that really the bulk of those changes, if I'm understanding you right, were subject to court interpretations, and they never went through the Congress, the House, and the President. Couldn't a reasonable person conclude that whole process was unconstitutional to begin with?
Well, the issue is when the courts decided, the courts are interpreting what the statute is, contemporary, with the facts they have in front of them to view it. So we have courts who revisit longstanding cases all the time and then decide what does that word mean. Now, some might just be, well, we think the prior court got it wrong. right? Or it could be in this area where, let's use the employment setting. There's definitely, if you went back to look at the legislative history of why sex was added in 1964, the Civil Rights Act, it was really limited to Jane Doe didn't get the job because she was female. She was otherwise qualified. So as time's gone on, the courts do have the ability to review that, and ultimately who decides if it's constitutional is the Supreme Court, right? So, and the only way that gets changed again is, so let's take the Bostock decision on transgender identity being a protected class underneath Title VII. The only way that the Supreme Court's decision would be rescinded would be either a new court comes in and says you got it wrong, right? The justices get a new fact pattern and say we made an error in that case, or Congress passes a law and says, no, you got it wrong. You said this was included and it's not. And so that's kind of the checks and balances that are there. But otherwise, courts can do that, and they do it, I don't want to say frequently, because the ones where they upheld everything as is are generally don't get quite as much attention as the ones where here's a change from some law that's been in place for a while, or we've expanded.
What Tony's saying probably could be right in France, right? It's a very different,
I'm not an
it's
expert in
a
French
very
law,
different
so-
legal system. But when you have a common law based legal system, of course the courts make law all the time.
Yeah, I mean,
And and it's always a guessing game. It always has to be tested because it's a guessing game whether, wow, your question is it constitutional or not? But the process is constitutional.
Yeah, I guess I'm just not sure if it changes so much over time. You know, when you look at the original intent to what it's morphed into, I mean, I think it's a lot different. And, you know, I just believe, if I understand it right, I believe there's, correct me if I'm wrong, but there are several court challenges in place right now with a lot of this language, and it's quite feasible that eventually that could reach the Supreme Court and they might agree with me.
on the student side, yes. I mean, and even on the employee side,
Thank you.
on the employee side, what they decided was relatively narrow. They just said, I can't decide not to hire John Doe because John Doe was born Jane Doe and it identifies now as John Doe. That's what they said. They didn't go in that case, and they've had opportunities and they've declined to do it on the employment side to say, which restroom can John Doe not use? Right? Can John Doe go in the locker room, whatever? They chose not to do that. They didn't take it up. On the student side, we have that Martinsville case, and prior to that, the Whitaker one, where they said they can use the restroom. Again, with those fact patterns for the kids. So it's, yeah, because the facts can obviously be different. Well, we got a kid here, and parents aren't consenting, hasn't been longstanding, et cetera, et cetera. You know, so there can be difference of opinions as to the facts on it. But they could have heard that case and said, no, Seventh Circuit, you got it wrong. The 11th Circuit got it right. You know, you can have
Yeah,
male only, cisgender has to just use whatever they were assigned at birth for the bathroom. They chose not to hear it, which, you know, for my sake, I would have preferred they heard it, you know, and then just
Yeah,
said,
right.
this is it, because then you'd have all 50 states in playing the same game. But now you have some that have no guidance from their courts, some that are like ours, and there are more that have viewed it the way that the Seventh Circuit has than the 11th. And then you have the 11th Circuit. So there's a conflict. And the courts don't always interject on it, but you know, one could view it as they didn't want to address the topic right now. For whatever reason, they chose not to.
Bob, what do you do you said some of this goes towards employment, and some goes towards student, but it's all in the same policy.
Yeah, at least for you it is. You know, there's a portion of it that's the same. And so that's something, obviously, you could talk to Neola about the pros and cons of having it all in one spot where you're at. You know, I think, I don't know your policies off the top of my head on the employment section. It might be repeated because you have the professional and support staff, you might have it delineated there as well separately. But the laws are slightly different on it. Now, it does say that you're not going to discriminate on those bases, and then when you get them, you go through it, because I'll use Title IX, for example. Title IX does cover employees, but more often than not, employees don't file Title IX complaints because I don't get compensatory damages through Title IX. So I file a Title VII or Wisconsin Fair Employment Act if I'm an employee and I feel aggrieved. Or for example, if I felt I was being discriminated against on the basis of disability, my attorney is probably going to pick state law over federal law, because the state law decisions have been more favorable on those topics than the federal have been, in general, all right? Not always, but in general. So whenever you try to put everything underneath one umbrella, it's sometimes difficult to, you either go very generic to make sure everything is covered, or you realize, okay, I'm going to have to, within that umbrella, still say this is here, because to like Tony's question, you could get a court that suddenly said Title IX is treated differently, and you've got to change the policy for students. Doesn't mean you have to change it for employees, or vice versa. Right? So when the Bostock decision came down, at that point, we did have a bigger gap because the employment was much more explicit on the rights of transgender individuals than Title IX was. Right? So for that period of time, you had that gap. Yeah, Biff?
Could you, I'm having a hard time understanding the 14th Amendment. It gives everybody equal protection under the law.
Protection.
And that's not true if you're not 18 years old?
No, it does when you're 18 years old. And when you're 18 years old, you're an adult. The tension is we also have Supreme Court decisions that talk about the parent's right to upbring their child. So that's the tension between those issues. And so you are correct that the government can't just suddenly say, well, I'm going to go seize this property from a 14-year-old. Right? They can't do that. At the same time, if you have a spot where from a 14-year-old, the parent's saying, no, he's going to be named Bob, and that's his birth name, and that's his legal name. He's going to be Robert or Bob. If I was to try to file the complaint, I'd have to get some outside group to do it on my behalf, and you'd have that tension between U.S. Supreme Court decisions that talked about the parent's ability to control the upbringing of their child with government's 14th Amendment. And the government 14th Amendment case would be, well, we're not treating Bob differently than anybody else, right? So he's got the same protection underneath the law. Parent has to sign off on the name.
So I get that, because parents should have say in raising their child. But what if the parents agree with the child and we're still discriminating against that child?
Well, I don't know if I would have to say what you're doing. That would be discrimination.
Like I said, it's a little confusing for me, because I'm thinking equal protection under the law.
Right.
And if we are honoring the parents, even with somebody under 18 who's not an adult yet, and we would say you can't do that because you're transgender or something else. To me, that seems that we're breaking that 14th Amendment if we worked with the parent. You know, if the parent says no, they would, as a school administrator, I would honor that, because you work with parents when the student is in school. But if they're agreeing with that, I'm wondering how we can say no if they're protected by the 14th Amendment.
Yeah, well, that's a good point, but that's what came up in the Whitaker case. Whitaker was out of Kenosha. They got to the fact that the parents and the student and the medical provider said the student identifies, in that case, as male. He should have the ability to go into the boys' restroom. And the district said, no, he's biologically female, he needs to go in the girls' restroom. And so the plaintiffs in that case, Whitaker, made the equal protection claim and won on that, saying, no, he has the right to use the male restroom or unisex, is the one he identifies with. So when you, and again, these fact patterns, and I talk to districts about them, I'm relaying what the court decision was. No fact patterns are identical. And so there can be a variation within them that suddenly you say, well, is this deviation enough to say that case doesn't apply? The Martinsville case, so the one that came out past summer, they had all these facts that you read it, parental consent, medical diagnosis, long history of accommodating the students, et cetera. And then they make the sweeping generalization statement. So that leaves the spot if Jim was to call me or your counsel and say, I got a kid, parents are not supportive, kids is just identifying this tomorrow, what do I do? I'd be like, you're gonna have a meeting with the counselor, the parents, the student, and try to formulate a game plan. And I think that's, you're trying to work through the issue versus the immediate, oh, let him go do, he can go play she can now go play on the girls' team, they can go in the girls' restroom, they can be called whatever they want, because then you're gonna have a parent concern. If you say, no, I'm shutting you all down, you're still identifying this way, or I'm outing you, and the parents are like, whoa, we're completely on board, then I could get the equal protection claim. And then you have the third parties impacted by it. So that's why I brought the athletics piece earlier. So there are some states who've passed some laws on that. Federal government's told them your laws violate Title IX. And then we have we don't have a court decision right now or case brewing that will cover you, but we have that Second Circuit one, which will give us some indication. And even the proposed regulations differentiate depending upon the age of the student. So fourth graders who kid identifies female and wants to be on the girls, if you were even segregating at that age, girls kickball team or whatever, the proposed regulations or the guidance documents are like, they can play on whichever group they identify with. Middle school, got to look at the sports a little more. When they get into high school or collegiate athletics, there has to be greater things to take into account so that now is there competitive equity, but physical safety. So like the NCAA rules on this have various testosterone testing limits, et cetera, that vary by sport. All right, so women's hockey has a lower threshold for testosterone in it than perhaps like tennis would or something. But a lot of this stuff is in a state of flux. And then sometimes, like when I saw the reference to the NCAA rules, it's like, okay, that works maybe if you're Michigan or Michigan State and you have all these resources, or UW in an athletic department. How's this going to work in a school district that has 100 kids in the high school? Yeah, you just don't have the infrastructure to do that. Now that isn't on the books. That's what's being proposed. And I think some of the reason why it's waited so long is trying to figure this out with the various competing interests, that are in place. Because you've got the one student with their gender identity, and they want to be on that team, and you don't want them to be harassed or discriminated against. And the flip side, you've got the other kids who, all right, is there a competitive equity issue? Is there a physical safety issue if I have someone who's 17-year-old male and then identifies female competing? You're a member of WIA, so WIA has rules on that have basically like a year-long time period where either if the student is identifying as female, has to go through and document various hormonal suppression, et cetera, that testosterone suppression, excuse me, in order to compete. But again, very, very fact specific and issues we take everything into account and look at whatever court guidance there is out there, try to guide your way through it. Any other questions on that? I think this next question I had was like, if you left the gender identity language out of the policy, it complies with the law, what do you fix for litigation? I think we already answered that. What happens if you included it and later the change is ruled unconstitutional in the courts? If it was, you'd take it out and then you'd go from there, as to that. If you allowed it to pass, could a biological male claim discrimination if they requested to use a different bathroom or locker facilities for biological females. So I think what this question was getting to is in the policy in some respects, I think is irrespective to the issue. But this is like the third party claim. So we have had some of those. To date, there's only been like one decision I'm aware of. There might be more, so I'll preface that. But in our circuit that covers us, generally the privacy rights arguments of others has not been upheld by the courts. Right, so I'll use the restroom situation, where others said the transgender athlete's going to go in, or not athletes, transgender student is going to go in, use the female restroom, and the female restroom has, I assume like yours is probably this way too, closed stalls, right? And the claim was, well, that violates my privacy rights as a cisgender female to be in that restroom. And the courts have not bought into that by and large. At least in our circuit, they haven't, and others as well. Because the exercise of using the bathroom is pretty private to begin with, right? Locker rooms, there have been decisions. The most recent one was that Martinsville one. But the Martinsville one went through, and they did afford the transgender student the ability to use the locker room. However, they put in that the students weren't asking for access to a locker room where the cisgender and the transgender student would be in a state of undress. And that they were comfortable with private changing areas, and that they were not, in essence, going to ever be in a spot where they were going to be fully unclothed in front of others, or that others would be unclothed in front of them. So with that fact pattern, they said, yes, they have the right to use the locker room. What that leaves unanswered,
that's pretty narrow.
their questions is, they didn't answer the question of, well, what if they were undressed there? Now, by and large, districts have been, no, we're going to continue to have locker rooms where we don't have people who have different anatomy in a state of undress in front of each other. And there may even be ordinances that come into effect, local ordinances as well. So if, for example, if you had a transgender male swimmer at the high school level, the athlete said, I don't want to wear a top. You could say, no, you still have to wear the top. There's a local ordinance that would prohibit you from exposing your breasts in that circumstance. So facts of these, again, can be complicated. But generally speaking, because the facts haven't come forward with situations where people are in a state of fully undressed, the privacy interests in like bathrooms has not been upheld in our circuit. Again, the 11th Circuit, Court of Appeals federal level, did. They did say, yes, an employer or school district doesn't violate Title IX when it keeps segregated facilities because of privacy concerns. The 7th Circuit didn't do that. Okay, let's see what next question we have. Can you confirm that the 7th Circuit Court of Appeals ruling in Whitaker versus Kenosha is the law of the land in Wisconsin? If so, would an attempt by the school district to discriminate against transgender youth expose the district to potential liability? Again, the first part of it is that case was in effect, it was held in 2017. There's a more recent one. And the more recent one, the Federal Court of Appeals, 7th Circuit, had the ability to go back and revisit. Tony, for like your question, court go back. They actually talked about how they were going to revisit Whitaker, but they chose not to change it, basically. They followed it. So they could have followed what the 11th Circuit said, because that 11th Circuit Court of Appeals decision came out in that intervening period, and they chose not to. So at least with the facts present in Martinsville, I would say that that case is the one that's controlling on you because it's the most recent decision. And that's the one, again, as I talked about, it had those fact patterns, parental consent, identification, etc., but it still had that broad statement. And as I mentioned before, the U.S. Supreme Court declined to hear the case in January. So I'm not going to, so if so in an attempt by the district to discriminate against transgender youth, I don't know what that really means, because that shows some intentionality versus, what are you doing? So if, for example, if the district chose to have parental notification with respect to like name changes, I wouldn't view that at the face of it to say, oh, that's discriminating, right? You've got the court tension there, which is different than parent consent on the name, et cetera, and districts say, I'm not going to call you that. That could be something where, all right, now I'm in a different spot. I'm more like this Martinsville case. And as I said earlier, that'd be when you check with your own counsel based on the facts and your liability area, before you proceed. Does that make sense, everybody? Should the board seek to pursue changes to current policies, will parents and families that disagree with school board decisions have the opportunity to opt their children out of those changes? For example, not participating in lessons on gender identity, being kept separate from students whose gender identity is different from biological gender in locker rooms, having restricted access to materials that do not align with family values. So I think we already talked about the locker room, that for right now, there is not a court decision that I'm aware of that controls your district that would say students have a right to be, transgender student has a right to be in the locker room in a state of undress around a cisgender student, also in a state of undress. Right? For the curriculum things, you have things that grow out of your local policies, but there's also state and federal laws on this. So for example, any sort of health curriculum that talks about sexual orientation or gender identity would be part of, I assume, your human growth and development instruction, which you have a committee that has staff and parents on it, et cetera. And a parent can opt their child out of that. So they have that ability to opt them out in part or in full of that programming. They can also opt out of portions of the health curriculum underneath state law. A parent can opt student or a child out of certain standardized tests and surveys, certain surveys that might call information under federal law, the Protection of Pupil Rights Amendment. There's also a state law that allows the parent to ask for what's called a program modification or curriculum modification, which is, I'd like my kid to be in this class, but I want this section of the curriculum not applicable for whatever reason. And I don't know if your policy, Jim, if it delegates that to you or if the board handles it, but the law says the board handles it unless they've delegated it. So this comes up most frequently, someone who wants to not be here for a full day because they're looking to become a child actor or athlete or something and their schedule's there, but it also would cover curriculum issues. Then you could also have it come up in the standard of a religious accommodation request. So in addition to those other things, someone could ask to be opted out of certain things because it's against their religious creed. And then you'd have to look to say the balancing of that person's religious creed versus any compelling governmental interest it has the child in that portion of the curriculum. Again, most of the time you're able to work that out with the families on these particular things. But the long and the short of it is, there are a number of areas underneath existing state and federal law that parents have the ability to opt their child out of certain portions of the curriculum that they feel are either in those areas I mentioned or are oppositional to their personally deeply held religious beliefs. Yeah, and you just go through.
Does that apply to, people who disagree with evolution and flat earth people and stuff like that too? I mean, I don't see the justification in many ways to say, well, okay, you can get a 13th century education. Because, I belong to, some cult that, meets in the forest. I mean, that seems strange to me that there would be a justification for that.
Well, to your comments or questions there, the issues will depend upon what it is I want to be out of. So if it's something I don't want to be in geography class for some reason, the compelling governmental interest may be much stronger to say, no, I'm not going to provide that. Or you as a board decide, I'm not going to grant that program modification.
Okay.
Right? But on the one on like human growth and development, it's right in the law that
Okay, sure. Yeah, I
just say,
understand that.
I don't want my kid in this at all. I
That's what I
want
was asking.
nothing about it. Now, if you do offer human growth and development instruction, this was back in the Governor Walker's administration, there's certain elements that must be in it. So the moment you flip the switch on and you have human growth and development instruction, there must be education on abstinence, the importance of marriage, et cetera. So those things have to be in it. The religious one, like you're talking about, not to revisit this topic that we're hopefully not going to experience again, but we got a lot of these accommodation requests with respect to COVID-19 mitigation protocols. That people said, I want a religious accommodation request not to wear a mask because it's against my religious creed. And then you go through the balancing of the individual's religious rights underneath the First Amendment versus compelling governmental interest to require the mask being worn. At that time, that was the debate on it. With the curriculum issues, where religion comes up, it's more in topics that almost bleed into the human growth and development instruction, in my experience.
Okay.
They're not to the Magna Carta, I'm opting my kid out of it because I don't believe in it.
Yeah, right.
It's not
Okay.
that I have seen. It's been primarily the creed is oppositional to something that most always is in the human growth and development curriculum anyway. Something like that.
Bob, regarding a follow-up to that question in terms of opting out, it suggests to me in terms of is, opting out when they stumble across something, or do you have to give advance notification, to the extent, how does that get triggered?
The parent files the request.
Okay.
So the parent notifies you that I do not want, and the parents can do this in multiple facets. So let's set aside the human growth and development piece again, because that one's pretty straightforward. So I want to opt my kid out of a certain portion of the curriculum because it's oppositional to our creed. Once that comes in, the first test you look at is that a bona fide creed? I generally tell districts, don't even fight over the creed, right? Don't even try to fight over the creed. Don't get into a religious debate whether it's a bona fide religion or not. Assume that it is, right? That it's a bona fide creed. Then once you have that, then you look to say, they have a seriously held religious belief. Is there a compelling governmental interest to not opt it out? And so the compelling interest might be, you say to the parent, if we're in geology class and you're going to opt out of this segment because it's oppositional to your creed, and this segment, this segment, and this segment, we've Swiss cheesed this so much, we're not going to view that you've satisfied this requirement. So maybe we'll do a program modification. Why don't you apply for a program modification and see if something else would qualify for that particular course. But my experience where these come up most frequently is we have something in a literature class or a history class. And the literature class is the assigned book is oppositional to my religious creed. All right, let's find a different book. Right, so we work with the parent, we get a different book. And so that's how most of them happen. That's able to do. It becomes a little more tricky sometimes in some AP courses. If it's like, well, if you don't do this, you may not be prepared for the AP tests because this is something we have to cover. And so there's very fact specific, and there's some tension there, but most of the time I found that you're able to accommodate the majority of the requests through either existing statutes or the program modification and working with the family to explain what's really going on. No, he doesn't have to read this book. We got this other book and this will satisfy it. And on the flip side, it's also educating the staff. A kid wants to do his forensic speech on how his belief in Jesus Christ has really worked for him in his life. And it's like, we allowed other kids to talk about how their working out has improved their physical health and stamina. He's allowed to do this presentation as well. So some of it it's a two-way street there. The teacher's not telling him, hey, Bob, why don't you do your presentation on the importance of Jesus in your life? But we're also making sure that if the kid wants to do that, he can, whether it's artwork or anything else. So just kind of having that dialogue with the family, that there's that flexibility in the curriculum. To some degree. I mean, obviously, the standardized tests, they can opt out of some of them. Some others, they can't, and then you'd have to make the call locally whether you wish to, what the breadth of that opt-out is. The next question I had, I think we've already covered this one again. Would removing gender identity wording from the district policies violate access to equal educational opportunity? I think we talked about that earlier in the beginning, Matthew. With it's really more the actions than the words itself. Then I had one is disbanding a school club a violation of the First Amendment. So with school clubs, we start first with you look at it from a standpoint of what have you allowed for clubs? So there's district-sponsored clubs. And then do you have like student-initiated clubs? I'm saying yes. So when you have student-initiated club, whether it's a robotics club or it's Christian athletes or it's a GSA club, whatever it is, once we open up the door, then we have the Equal Access Act could come into play. And that federal law basically says that it only covers secondary and post-secondary schools. So this is not, the equal access law doesn't apply to third graders. So we're talking high school here. So if you allowed a high school club for robotics, and you had a request for a GSA club or young Christian athletes, both of those clubs would be permissible, provided you were still able to find an adult to supervise, not to lead. The adult can't lead it or direct it, but the adult's there to supervise the students for that. And so when the question is disbanding a club a violation of the First Amendment? Well, first, you have to decide, are we opening up the door for student-initiated clubs? If the answer is like yes, then we go through the criterion of, did you find an adult supervisor? Do you have a showing of interest? I just couldn't create a club of, the Bob Butler Greatest of All Time Club and say, let's have that. And there's one member, me, you'd say, okay, well, it's not a bona fide club. You can't get a teacher to work with you. But otherwise, you go through that dynamic. And at times, you probably have some ebb and flow of either not having adult supervision of the student-initiated club or the kid's interest wanes. And so you decide, yeah, this club was really popular. The rock guitar club was really popular 20 years ago, and now they want to do country club or hip hop club or something. So we disbanded the rock guitar club. So it depends on how it's initiated and whether you've created that open forum for the clubs. I don't know if there's any questions on that or not. I had a question on is like taking down stickers from doors considered a form of discrimination or violation of the First Amendment. So the district owns its property. And so you get to decide what goes up on your walls in a general sense. So if you have sayings up on your walls right behind you here, and the district can decide whether they're going to open that up to create a forum for some form of expression or not. So some districts have policies and procedures that explicitly say, we own the walls, we own the doors, etc. And individuals are only allowed to put up curriculum materials. They might have small personal effects on their desks, pictures of their dog, their family, whatever. But I can't suddenly just go up and put up something that's not curriculum-related on the wall. So I'm a big New York Yankees fan. I can't have my entire room being New York Yankees while I'm teaching A-push history, and there's absolutely nothing about history there. Right? The district could do that on a more benign topic, right? Because we want to keep it curriculum focused. If we opened it up, though, using my analogy, and I'm allowed to put up all my Yankee paraphernalia, and you come in and say, well, Bob, that's fine, but John Doe, he can't put up his Gadsden flag or something. Then we'd have to say, well, why is my Yankee banner okay and his Gadsden flag isn't? Now we do have some court decisions, not one in Wisconsin, but we've had cases where even when it's wide open, we can say, well, he can't put up a Confederate flag because that flag in and of itself could create hostility in the learning environment, could be viewed as being discriminatory towards certain students, and it's disruptive. Where another flag the colonial flag that Betsy Ross did, it's not going to have the same reaction to it. So the short answer on that is it depends. And it depends upon your policies you've adopted and the practices you've implemented. But legally, at the front end, you have the ability to control your school environment, provided that it's done in a viewpoint neutral basis if it's not curriculum related. Any questions on that one? What rights do students have regarding using gender pronouns, and would they be forced to use them? So as far as I think we've talked about if the student identifies a gender different than that assigned at birth, their right to use that pronoun would be subject to the law, and then also how you've codified that in any sort of naming policy you have. And that's something that I do say, whether through practice or procedure, however you want to do it, that there's some clarity there that clarifies the rights of the student and the parental involvement if they're under age 14, if they're 14 to 17, and they're 18 or above. If you have the fact pattern where another student says, I'm not going to refer to that student by their new name, or a staff person says that, well, I'll start with staff person first. The staff person issue is presently in the courts. So there's a case out of Indiana where a staff person refused to refer to the student by their preferred pronoun and preferred name, and the district terminated the individual basically for insubordination, refused to do it. Parents had signed off on the name, it was in the database, and the staff person refused to do it. Staff person lost at the district federal court level, staff person lost the Seventh Circuit Court of Appeals. And then the US Supreme Court issued a decision called Groft versus DeJoy that involved a postal worker who was forced to work on Sundays. His creed was such that he couldn't work on the Sabbath, and he was terminated for that. He filed a complaint, and he wanted the Supreme Court not necessarily to get his job back, but just that the United States Postal Service couldn't just use a very low bar to decide if it was, in essence, was it an inconvenience. No, they had to show it was an undue hardship to accommodate him. How that case relates to the pronoun name piece is, after that case came out, the Seventh Circuit Court of Appeals kicked it back to the district court, which is where it sits now, to say, in light of that Supreme Court decision, could the school district have offered more accommodations to this person based on his religious viewpoints, or not? And there isn't a decision on it, so I can't tell you what that one is. It could be like, no, we offered all the accommodations. We offered him that he could call him Scholar Butler, but he wouldn't do that. He would only refer to him by the name, and so that's why we did it. I don't know how that will turn out, but that's where it is now. For students, it's kind of a similar issue. I don't have a court case that definitively says that, well, my religious creed is there's only two genders, so I'm not going to call this person they or their other name. And that's, you've got the Title IX side on one side, and you've got the religious discrimination or accommodation issue on the other. I don't have a court case that I can tell you, yeah, this is how the court has treated that issue. So again, hopefully you're able to work with the parties to come up with resolution there that satisfies everyone's interest. So the student with the religious objections is being accommodated, hopefully, and the student who's transgender doesn't feel they're being discriminated against because the other student continually refers to them by their old name or their old pronoun. That's, as I said, we don't have a case that really defines it. It's an open issue right now. But I think this one's redundant as to what we talked about earlier, what protections would be able to be put in place if a parent doesn't agree with the board policy. So it's the same thing we talked about with the opt-outs in the program modifications. Is there a way to protect my children from being exposed to sexually explicit materials in our school library? Yes, the district has a couple of different policies that talk about curriculum and as far as access to library center materials, other information in the curriculum, and then it's the same thing we talked about before with the opt-out of certain portions of the curriculum, human growth and development, et cetera, and the religious accommodation requests. So all of those are the same. And those are pretty much the preset questions that I had that I gave a response to. So I don't know if there's questions or topics that you'd like to revisit or something I didn't cover. Yeah, Tony?
I have a question, and Jim, I don't know if you could maybe chime in here, but as far as I know right now, we don't have a clear or formal policy on transgender students with restrooms in the district, do we?
I don't think so. We don't. You know, I only know that we have a practice of separate bathrooms that we accommodate people.
Right, and that's my understanding too, so, in the absence of a clear policy, and to Jim's point, just to give you some background, the district's made accommodations for separate facilities for these students so that they have access to them. One of the concerns that I have in the policy or in the specific gender identity language, you know, as it relates to the non-discrimination policy, is if we allow that to pass as written, you know, what would prevent a male from using the women's facilities? Let's just say it's a locker room, right, or a restroom. And if we say, sir, we're sorry, you can't use that, you have to use this other room, couldn't the student then claim discrimination if we don't have a clear policy on it?
Yeah, I mean, you can have a claim whether you have the policy or not, Tony. I mean, I think the piece will be, when districts have done this, some have opted to have policies, some have not. When they've applied it though, there should be some guidance that the administrators have. And that guidance can either be from Jim taking it or for you saying, these are our general parameters we have, even if we're not adopting a policy. Where I have seen the general viewpoints of it, and this is a generalization.
Yeah.
It's been restroom utilization is, we start with age of pupil. So the adult pupil has a lot more autonomy. So the 18-year-old, he identifies as she. Okay, we don't have mom or dad involved in it anymore, out of the equation. But you could still have that person meet with the counselor and say, what is it exactly you want as an accommodation? I want to use the girls' restroom. Okay, you want to use the girls' restroom. What about the unisex restroom? Would that work as well? No, I only want to be in the girls' restroom, and I'm identifying as female. Probably going to be one where underneath this Martinsville case, if I got that call, I'm going to say, so you're probably going to allow them to use the girls' restroom because of the way that court decision is written, because it's an adult. If it's a minor, then I'm bringing the parents in on it. And the parent, that'd be my advice to the district, bring the parents in. And if it's like, well, the kid says dad's going to hit him if he does this. Well, we got a CPS, we got a child protective service issue. Yeah. And honestly, I don't get that fact pattern very frequently. It's more of the times it's like parents are uncomfortable, the kid's uncomfortable coming out of it. And when I've done presentations with other attorneys on this topic and with counselors, it's saying to the kid, do you really think that if you start identifying a different gender at school or using a different restroom, your parents aren't going to find out about it? So they're going to find out about it. Let's work together on this as a group and use your help. I also advise to teaching staff that kids will often confide in a coach or a teacher that they trust, right, on these topics. But if I had that happen where some student came to me with that fact pattern, I'm going to say, let's pretend Jim's the counselor. I say, if you have faith in me to come to me and express how you feel about this, you need to see Mr. File, because he's the pro counselor. If you trust me, you need to go to him. I don't want to self-help and keep that information to myself and then have the parent upset at me as to, you were calling a different name in the classroom and didn't tell me about this. You were allowing him to use the restroom. You know, I don't want to put the teacher in that spot. I want to have the counselor involved in it, and so you have those set procedures and protocols to handle it as a district. So if you do have clarity as to, even without the policy, we meet with we have the counselor, we have a central person, counselor, parents, and we come up with a game plan as to how it's going to work for that child, plus the kids who are going to be impacted by this. And then we have to have some form of communication plan to the staff who must know. Because even if we work things out with the kid that they can use the restroom, the custodian or the paraprofessional may not know it. And they go, hey, Bob, what are you doing going to the girls' restroom? You know, call me out. And it's like, well, this has all been approved. So that staff would have to know this kid's allowed to use that facility for this purpose. You know, so they know that fact pattern beforehand, so we don't stumble into something. So what, you don't have to have a policy on it, but it's good to kind of do some brainstorming at the administrative level, if you haven't already, with some guidance from the board as to how do we proceed on these. And as I said, most of the districts that I should say most, just about all of them we're working with the student and the parents on this, of the affected student, and we're thinking about how that will impact the rest of the educational environment for that kid. And we go from there with it.
I'm hearing you right. We don't necessarily have to have a formal policy if we're following procedures. Is what
Either way,
you
they claim.
you don't have to. No, there's nothing that says you have to have a policy or procedure. The pros and cons of having the policy and the procedure are, the positive is, if I'm the classroom teacher and the kid comes to me and says, hey, I want to now go by a different name and I want to use the girls' restroom, I know, I pick it over here, and it goes through this deliberative process and the parents are involved, et cetera. That's perhaps one of the positives with it. The negative with it is, you know, how do people view the policy or the procedure? You know, and so that's where you get the debate of what if the parents are divorced and dad says yes, mom says no. What do I do now? Or the kid's like, I want to be known by this different name, but I don't want my parents to know. Or I still want to use the same restroom. I'm kind of transitioning. I don't know if I'm really sure about this. Or I'm non-binary. I want to use both. You know, and if you don't have a policy, what do you do with that? So it's good just to have that conversation. And if I was an administrator, though, I would want to know where the board is on it. I'd want to know explicitly, yes, we are a parent involvement for the minor child board. All right, that's where we are. So if I'm the counselor, I don't sit there and think, well, my creed says I don't tell anybody about this. And later on, the parent finds out and gets really mad at the district and at the counselor for not sharing that the kid had all these conversations about their gender identity and has been identifying a different gender at school. I mean, that to me is the worst case scenario for everyone.
And I think how you alleviate that exact problem isn't, everything you said I agreed with. However, I think the first stop should not be in your scenario, Jim, the counselor. It should be directing that student back to their parent. That's my opinion. That's where you're having that, because you're trying to say parent involvement needs to be there. I think that's where we should be directing that student back to the parent about that conversation.
Don't disagree with you, Matt. The one issue that I don't know at that point is
Situation.
I don't know the situation if the kid, because I don't want the teacher really doing much of any intake.
Correct.
So when I give it to the counselor, if the kid says, yeah, I identify this way and I don't really want my parents to know because my dad beat me up over it, that's the tension there.
Correct.
That doesn't, and again, I don't want to say my personal experience is all encompassing. We don't get, the vast majority is that they may not be jumping up and down doing jumping jacks over it, but they want to be involved as a family in that piece. So the referral to the counselor is so that the classroom teacher isn't making the call. I want to get the classroom teacher out of it as soon as possible. The counselor may say when they meet with the kid right away, we're going to bring your parents in. That might be their very first thing. I'm just bringing them down the hallway to the counselor. That's basically it.
I'm just advocating for the relationship between the student and the parent right away. And I understand that there's scenarios and there's conflict, but we shouldn't give the rights away of the parent so quick to say the counselor needs to be involved before the parent's involved. That's the only point.
I got you.
In addition to that, and I agree, I think that's why we have the parental bill of rights and what we've added as guidelines, because we are a very parent involvement district. So our our policies or guidelines would state that as long as the parents are aware of it and the parents sign off, they give us a, you know, a letter or whatever, and we do have students that have, you know, we've been given instruction by the parents to be addressed as opposite, and we allow that. So, but we are very much a parent involvement district.
I don't think what I'm saying, what you're saying are really at odds, because I'm just talking about when it comes in, the teacher's not making any substantive call at all.
Correct.
She's just bringing them over here, so then the parents get called in, because my worst case scenario is
Not telling the parent.
the parent doesn't find out and the teacher just starts doing their own
Correct.
thing.
And I'm saying there's history of parents not being involved, so that, how do we cut that problem out, which we're all addressing? Saying you get the parent involved right away.
Right.
So we keep, because once somebody was told something, then are you null and void, or you did your due diligence because you passed it off? That's where there could be negligence, because you say, well, I'm washing my hands from the situation because I passed it off, but we don't really know what happened.
Yeah.
That's what I'm trying to say.
I know what you're saying.
So the first step,
Yeah, the difficulty always from my standpoint
From
dealing with these is teachers are very well intentioned, but I'll pretend I was the high school history teacher. I wasn't trained in this area. So when it comes in, it's just like if the kid shows up and has a fever, I bring him to the school nurse.
Right.
You know, it's the same thing here. And then the school nurse contacts the parent. So I don't think we're saying anything different. The parent is going to be contacted within minutes, hours of when this is happening. I just don't want the teacher being the outreach to the parent right away, because they may not know the proper way to communicate that to the parent.
and I just don't want a chain of custody loss of that information.
Right.
From the situation that was brought up to the parent. That's it.
But that's you guys debate that, that's a policy piece.
I know from experience in my own family, my extended family, that, you know, it isn't always clear with kids what they are. I mean, you know, I have a relative that was for, you know, born female, was female. And then about the age of 14, she thought she was a boy. And there was all kinds of flack at school because she was, you know, in arguments with the phy ed teacher, for example, et cetera, et cetera. So the period in which she identified as a boy lasted maybe 3 months. And then she became interested in a boy and became a girl again. So is there any measure of validity on any of this stuff? Like, okay, I mean, I would certainly respect someone who was absolutely convinced, was mature enough to make a decision like that. You know, that would be more than a 14-year-old, I guess. To say, okay, I'll accept that. But is there any kind of validity test on any of this? Is it just opinion?
I'm not a medical professional, so I'm just going to keep it to what the court decisions have
Yeah,
done. And the court decisions that are controlling on you have all had student plaintiffs who had, if not medical diagnoses, they have long-standing identification with parental support.
Okay.
Right, so, and it's a great question because we get it frequently as to the kids just decided this. And my first thing is, where are the parents? And then it is, how long is it? And although the medical documentation is not necessarily necessary, it helps in the decision-making as we go through. And from a legal standpoint, when you work with that, with the family and the counselor together, you may come up with, all right, because a lot of times the kids when they're transitioning are name, pronoun first, restroom may be way down the line, you know, or trying to be on a different sports team or whatever else, way down. And so you work with that, but I don't have anything that's, the court decisions have used the gender dysphoria diagnoses to make a decision on it.
Okay.
And at least the most recent ones, the students did have the diagnoses. that has not been a uniform piece. But they have all had there hasn't been a case yet that I've seen where they've said the kid's got the right, even though the parents said no. Right? They have not had that fact. So I think when you're looking at it from a district standpoint, if you were talking about there earlier with the parent involvement, that's where you kind of have the piece as to where does it go and how quickly do the accommodations go into effect.
Yeah.
If we pass the non-discrimination policy to include that gender language, let's say we had an incident that, and this actually happened, I believe, in Virginia about a year ago, where a male physically assaulted or sexually assaulted a female student in the locker room. Or it might have been the bathroom, but either way, it was a woman's space. What liability would we face as a district for that?
I don't believe the policy in of itself would be the determining factor. Now, one thing you may put in the policy, walk this from Neola folks, when I draft these policies, I put in, you will not unlawfully discriminate on the basis of bing, 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 bing. All right. And the reason why I put that qualifier in there is if I don't have the qualifier in that it was illegal or unlawful, there you get into that vagueness as to, well, you still made a decision based on my sex, for example. It's like, well, yeah, we put you on the girls' softball team because you wanted to play softball. No, I want to be on the baseball team. All right, well, we didn't know that. You know what I mean? It's that an act in itself, putting the girl on the girls' softball team is discriminatory at the outset of it. So I'd want to have the illegal in there. Then as far as what would happen if, like that Virginia circumstance, where that student was not transgender, the student in that fact pattern, that was boyfriend and girlfriend, and boyfriend dressed as a girl to have the meeting with girlfriend and then sexually assaulted the girl. And so if you have solid procedures in effect, so we were talking about earlier, I had the example of the custodians and paraprofessionals knowing it. If that was your protocol and you knew it, if that kid went into the girls' restroom and someone saw them, would have been, whoa, 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 John, what are you doing going in there? You're not allowed to be in there. You know, I'd rather have the check and then verify and say, okay, you're good, sorry, or you're not allowed to be there. But the liability in that fact pattern would be the same whether it was a heterosexual male did the attack in the girls' room, the boys' room, etc. Where that became really controversial was not only the horrific act of the sexual assault, but also that the information wasn't shared with the district that the child transferred to. So it was how was a sexual assault treated, and then it also got into, was someone, for lack of a better term, pretending to be transgender to take advantage of another student. Yeah. All right, so when we talk about those internal protocols, there's not a district I've ever told that, oh, the kid came in at 8 a.m. and just walked into the girls' restroom, that's okay. You know, no. We're rewinding the tape. You have to go through all of these steps to see, is that the appropriate accommodation there? It was a horrible situation that happened. But yeah, I do pupil expulsions, and any time we have a student sexually assaulted, it's a terrible fact pattern. Then you go back and look to say, where were the gaps in our procedures that, if there were any, that allowed this to happen, or was it a crime of opportunity here that someone took advantage of? I don't know if that.
Yeah, it sounds like either way, the liability's not gonna change.
Well, I think where I would be concerned would be more in the situation of there is no process up front to see, is this person allowed in the locker room? Are they allowed in the bathroom? It's just a complete free-for-all. That's where, if I was the parent of the victim, and we said, well, we accommodate everybody, and if they identify a certain way, we allow them in. So literally anyone could show up at any moment and just go into that restroom. Yes, we don't monitor it at all. Okay, that might have a different liability than no, they broke the school rule. They were not approved to be in that restroom. They hadn't gone through our procedure. This is how detailed we are before they have the ability. So it's only bona fide students who they have a good faith belief in self-identification as being that gender allowed in. I just can't go this morning and say, oh, I want to go check out the girls' restroom.
So you have to have a policy on that.
You don't necessarily have to have the policy. You just have to have something that this is the way that we enforce our existing, it's just basically administrative discretion as to how we handle the utilization of restrooms or locker
But
rooms.
it has to be consistent, yeah.
It should be consistent. Now granted, if you said, well, it was after hours and the boys' room was being cleaned and I went in there to go to the bathroom because no other bathroom was available, that's a different fact pattern than this one of they were planning to have their hookup that they've had in that restroom before. They get there, she rebuffs him and he sexually assaults her. But he got in there by wearing the skirt or the dress or whatever, pretending that he was transgender. That's creepy.
Robert, I have to admit, I didn't want to come here tonight. I'm not a huge attorney fan.
Neither am I.
Shakespeare, yeah.
But I have to say, probably the last 15 minutes of the way that you were explaining how to handle situations. I mean, the reality is, we're going to get sued one way or the other if something happens. But the reality that you talked about on ways to handle situations with kids that I don't want to say need help, but kids that struggle because sometimes it's hard to be accepted. And the point of trusting the educators, the counselors, the people in the building to come up with solutions before it gets to a situation that we hear about. And that to me has been very valuable. I think that we need to look at those kind of things, You hear about Sun Prairie and what happened there. Well, that was a situation, there was no coach or gym teacher or somebody in a locker room and kids were unsupervised. And part of this issue that we're having, or which restroom can I use, part of that is going to be school policy and how we come up with supervising situations to make sure everybody's safe. And I appreciate that part of your presentation the most. And I even have a little more respect for attorneys now.
Well, the goal is that, my view is always like, be the Fram oil filter guy. I would rather get it up front than have your lock. So, it's already talk through things up front and you figure out what works for you. And like I said at the very beginning, there's areas where I can say, this is what the court decision says. But then when it hits the ground, like Tony asked the question, the fact pattern. All right, well, they weren't talking about that fact pattern court decision. So they were talking about, we had all this notice, we checked all these boxes, and then this kid went into this environment, which is different than your point, Biff, on the supervision. You go pick whichever restroom or locker room you want. That can open up more exposure without doubt. Yes, Tom.
Yeah, one final question I had, just to make sure I understood you right. It sounded to me like my big takeaway from the presentation is that if the board elected to leave that gender language out of policies, there's nothing against the law to leave it out. Is that right?
That is correct. For the gender identity.
It's actually not in the law.
That's correct. It's in the court decisions of interpreting the word sex.
Yeah, that's why I was going back and forth before, because I was checking the definitions at 11132, I was checking the PI 9 and the current Title 9, and it is actually not in there.
That's correct. It's not in any of them. And so it's just when that word has been interpreted by the courts, they've included that within it. And again, as I mentioned, the employment one for Bostock was very broad, very generic. The Title IX ones and make that generic statement, but then they say, we don't have to address all these things because I had parental support, I had medical diagnosis, it was longstanding, et cetera, et cetera. Yeah.
Do you have a Black's Law Dictionary of gender identity defined?
I don't,
Can you-
I use,
Because I asked that question, it wasn't.
oh, I didn't have that in here.
I'm sorry. So
Yeah, I don't have
know how
that.
I sent it, but gender identity, I would want the legal definition of that.
The best definition I can give you is in that Martinsville case, the court references, I believe it was either APA or the court in a footnote. All right, of course, this is the way it does when you try to figure it out, because it's a great question. You know, what does it encompass? They use the APA definition as a reference, which ties back to, you know, basically paraphrasing it, but an identification of your inherent self that's different than your physical anatomy. It's something along those lines, right? That's the general gist of it. But the court decision does reference it, Matt. They have it in there. They don't spend a lot of time on it. They just say gender identity and they've got it referenced in a footnote, but it ties back to the medical definition there. And then the other piece where it shows up beyond that is in those the proposed regulations have it there, but that's the most common touchstone as they go back to the medical terms on it.
I have two questions. One, WASB also is like Neola in the sense that it has policies, correct?
Correct, correct.
Okay, and in the policies that you have on discrimination in your template, do you give the school boards an option? Does it have the language in there in parentheses on sex as an option, or is it already in there in your template?
Sex is in all of them. There are options that a local district could choose to put in gender identity, and there's options where they could choose not to.
Okay, so that's in the WASB.
Either way.
They're both in WASB.
Okay.
Well, they're not, they're separate options. So like sample A, you could adopt and it just has the Title IX definition that you were referencing.
Correct.
Or you could have one where you included the term in if you wanted to do so. They both will say, though, that it protects against unlawful discrimination, because why I always put that term in there is through experience. I don't want to get into the, and districts have, I should put it this way, some districts are like, no, I want to cover behaviors that are perhaps, we view them as being inappropriate as discrimination, even if they're not unlawful. And I've personally taken the view of, I'd rather have it at the unlawful level, and if you don't like it, treat it as a student code of conduct issue or bullying.
Correct.
I don't want to give it all these procedural elements like it's illegal, unlawful discrimination. But that's, you know, different attorneys can have different opinions on that. Debate them, so.
And then my next question is, you know, how you were talking about the duplication of policies based on I know WASB's hundreds, right? You guys do 100 labeling system and Neola does 1,000s. So my question is, like, this policy, right, 2260 falls under program, but then the same policy shows up under is like 3122 that falls under a different category. So when we're talking about the one that goes for employee discrimination, based on what you were saying before, does that gender identity language need to be in that one for employment?
3122. Is that the one you're talking about?
Does that make sense?
Yes, it does. So again, the law exclusively talks about sex. So when I'm called up, like your draft or your policy here, where it says transgender status, change of sex, there's nothing wrong with that policy, you know, if you chose to put it in.
Yeah.
At the same time, you're not compelled to put that in because the term sex is defined by the courts.
Okay.
Right there, okay, so that's a judgment call.
Kind of redundant.
It's a judgment call on your behalf, you know, and as to where you want to be. Either way, using that employment situation, Jim couldn't refuse to hire me as a third grade teacher if I identified female, whether it's in there or not in the policy.
Right.
But the law itself, the statute itself, does not include those terms.
Would you be opposed to crafting the policy to divide employee from student to have the student encompass the parent? You talked about it earlier.
Yeah, no, that's why
I'm trying to.
No, I have not been opposed to that. If districts want to put in and many of them have done that, a parental notification, parental agreement on various processes. So no, I have districts who have adopted that for names, pronouns, restrooms, athletics, et cetera. You know, that it has parental involvement and agreement for the minor student in it. And on the name ones, again, they can get a little bit trickier because under age 14, the kid, underneath common law, the kid can say, oh, I don't want to be known as Robert, I want to be known as Bob. All right. And schools have generally agreed to that, although you don't change that in the official student information system. I couldn't go to court though and change my name to be Bruce when I'm 13. Parents would have to sign on it. Once I'm 14, I could go to court even without my parents' consent and get a name change order from the court saying I want to be Bruce. Historically, in my experience, it doesn't happen very frequently. It most of the time happens when there's divorced parents and a kid doesn't want to have the same surname as one of the parents anymore.
However, there is no case law for compelling the teacher or staff member to call them by that name.
That's what's open right now.
Yes.
That's that clue case. So a few months ago, I would have said, yeah, you can compel them to do it. Now it's unknown. It's uncertain where to do it. And when I've had them, yeah, it's again trying to work through things. It's like, you know what? We're going to call everybody in the school Scholar. So it's going to be Scholar Spalding, Scholar Trask. That's what we're going to do. Because we're just not going to call the one kid Scholar and everybody else goes by Jamie, Jen, whatever. You know, that's how we're going to handle that if I'm trying to avoid the lawsuit in either direction. You know, and that's, or everybody's going to be called just by their last name. It's going to be like, Phipps, you're up. That's what it's going to be.
That's what they did when I went to school.
So that's a way of buying time, so to speak, and accommodating the religious beliefs of the staff person and the rights of the student. Now, the decision may come out saying that the district, in that Indiana case, had the right to compel the teacher.
To their employee, maybe, right?
Correct.
Then we would open up the other party, the other students that were not feeling compelled because of their religious belief to affirm whatever they're trying to be told to affirm.
Correct, right. And
That's a whole nother, we haven't got to that yet.
Well, that's the piece where I said you are balancing that. So if I said my religious beliefs as a student is there's just two genders, and so I will only refer to Bob as Bob, not as Jacqueline, then that's where, again, we work with them and go, all right, all the kids in that classroom are going to be known as Scholar. Because I'm not going to have it where either that kid's calling me Bob or Jacqueline's the only kid who's being referred to as Scholar. You know, because again, I'm still singling that kid out. But that's the type of practical thing we try to put into effect until someone gives us more clarity legally. Yeah, because it's, as you said earlier, if I went the one way or the other on that, no, Matt, you're going to call him you're going to call her Jacqueline, then we get the claim from your family. If I say, no, he can call her Scholar, but nobody else is, then we get the claim from my family. You know, so we try to come up with something that's neutral, and people will make mistakes. You know, and I've done this presentation with staff, they go, oh, they're really worried of, like, are we going to get sued if I've known Bob as Bob or Bobby for 8 years, and now she goes by Jacqueline, and I called him he the other day, or you know, am I going to get sued? It's like, no, not going to get sued over that. If you do, I'm not worried about that. It's more, are you denying him some educational opportunity or creating a hostile learning environment? That's more than just the occasional mistake in the situation as you go through on this. Other questions? You guys asked a lot of really good questions on this on a very difficult topic because you're balancing, you know, the rights of different parties here while trying to have a good, productive learning environment for everybody.
I had a question, not a question, maybe you could agree or disagree with me. I would see as an employee or a teacher, I could see it being a lot more easier for an employer to compel them to call them by certain name as opposed to other students who are not employees and have their own.
That's religious belief.
Right, so I mean, that's kind of like, the two different things being, it'd be a lot easier for an employer to compel an employee as opposed for us to tell a child, you have to call them by this, because that's infringing on their freedom of speech. Like, they can call them, as long as it's not, you know what I mean, vulgar or anything that's against their policy, we really can't control that. As far as what I see, I'm trying to think, yeah, okay.
That's pretty much where the Seventh Circuit was before the US Supreme Court came out. But when the court decision came down, and I don't know if in that fact pattern at that district, if they had offered or showed what would be the hardship if we called everybody in that classroom scholar, so the teacher made an observation of his religious beliefs, didn't have to call Bob Jacqueline, right? I don't know if they offered that or if they just said, no, you're calling her Jacqueline. You have to do that, because we're not just gonna have the classroom, this particular classroom, have something different. But I have had that fact pattern, and we've gone the scholar route, and it seems to have worked, you know, where everybody's being treated the same in that class.
But
In the student information system, you control the student information system. So if the employee said, well, I'm not gonna enter in the grades because it says Jacqueline in there, I think that'd be a lot weaker of a.
yeah, that's different.
Yeah.
Right.
Anything else?
Thanks.
Thank you very much.
Thanks, Bob.
Thanks, Bob.
Okay, so we have, on the agenda here, we have the unfinished business policy that's been tabled 2260. The non-discrimination and access to equal education opportunity. This was for the first read. We never went beyond that first read and tabled it. And so is there any action anyone wants to take with that 2260?
I'd like to make a motion to remove the language including gender status, change of sex, or gender identity from the policy.
What line are you talking about?
So this is 2260. The second paragraph, starting with the board does not discriminate. And in parentheses, there's including gender status, change of sex, or gender identity in parentheses, which is a defining sex.
Could I add to your, or like, say something about your amendment? I don't really know.
Make a friendly amendment.
A friendly amendment? And I would like to add I'd like to add that wordage in there that Bob kind of leaned towards, is the unlawful. The board does not unlawfully discriminate. And then I would, as far as the wording on there, I would like to just keep it exactly how it is written in Title IX.
How is that?
Is that in the same, I'm just trying, I don't have the policy, is that in the same?
That's in 2260 we're talking?
Yes.
Yeah, so
First sentence.
I would just make a friendly amendment that we change it, the board does not unlawfully discriminate, and then the rest of it keep the same as Title IX.
So then not removing what Tony is
I
suggesting?
believe it does actually remove,
At Title IX, it stops at the word sex. There's no parentheses.
correct.
So it would read,
Parental status. Sex.
it would go parental status. I'm just shortening this, sexual orientation, sex, and then skips to or physical, mental, emotional, or learning
Correct.
disability.
And Matthew, if I heard you right, you wanted to add unlawfully in front of discriminate?
Yeah. Yeah, I kind of agree with him in the manner of that kind of, like he had said, if there's other points in there that we wanted to add, or that could be held under different policies or whatever. This unlawfully is, kind of leaves you open, because there is, they do, I don't know if you want to use the word discriminate, but I mean, between men and female. I mean, there are certain things that that the laws and whatever, even currently on the books, that they can and cannot do, just unlawfully kind of softens that. But that's, I mean, it's kind of up to you. I really just want to keep it exactly how Title IX is written.
Okay, and it is? Does it say unlawfully?
Does it have that part in there? I'm trying to look for the exact
I
copy.
mean, I'm not objecting to that. I mean, it's a kind of a cautionary term.
Right, yeah, that's kind of what I was thinking.
It does not.
It does not?
Well, I'm sorry, I'm looking at the state law, PI
The
9.
PI, correct. Well, we could do, the PI is different, yeah, and it defines all of that. But it says, which provides that no person be denied admission to any public school or denied participation in, be denied the benefits of, or discriminated against in any curricular, extracurricular, pupil services, recreation, or other, he said it was a lot more in depth, based on a person's sex, race, religion, national origin, ancestry, creed, pregnancy, marital, or parental status, sexual orientation, or physical, mental, emotional, or learning disability. That lists all that out. And that's specifically the pupil public instructions Title IX. And it has all of that in there, but it does not have the, based on the transgender status and the gender identity and all the other things that are still, as of right now, in the courts and very confusing.
So Tony, to you, Matt's making a friendly amendment to add the word, to add the word unlawfully prior to discrimination. And then remove the parentheses. So are you okay with that friendly amendment?
Yeah, and it's gonna remove that language within the front.
Correct. Correct.
I think I'd be okay with that.
Okay, so then okay, so seconded by Matt. Any discussion? Chris?
I think the more explicit you are on what you don't allow for discrimination, the better you protect yourself from discrimination. I would not strike those, because if we end up with a case of discrimination after that, the argument can be made that the board allowed that discrimination. So I won't be voting for it.
According to our discussion with the lawyer, whether those are in there or not, the argument can be made.
I thought it wouldn't make any.
So,
And I guess my thoughts on that are, if we leave it in there and someone with a penis wants to shower with the girls, they could claim that we're discriminating by saying, no, you can't do that. So that's why I'm gonna vote to remove it.
I don't know if that's.
Somebody said, but
It's not what he said.
That was my,
said, but
I think, in my opinion, the reason why I state the way I am is because what I got from him is that whether it's in there, whether it's not in there, the case can still be made. So as of right now, I would like to stick to exactly what the Title IX says. And that way, in my opinion, we're covered by stating, this is what you have written, this is what we have in our policies. That's why I'm stating that.
I would be voting yes, because I like how he was saying the fact patterns of each case, that pretty much brings it down to the individual level of each individual situation. So like other people have said, no matter what happens, somebody can still try to make a claim, but if the fact pattern is not aligned, then obviously they're gonna get rulings on it either way. So I don't see a disadvantage of doing it, voting for the change.
Well, what he did say is like, sex says it all, right? I mean, it includes all of these things, doesn't it? And so, in a sense, it's like,
Redundant.
either way, I mean, it's a little redundant, yeah, it's a little redundant, but either way, I mean, it doesn't cut anything, you know? I mean,
And it doesn't take anything out, doesn't leave anything in.
yeah.
Whether it's written in there or not, as of right now, the law is the way it's written. It's kind of how I see it. So,
I think it does take something out. Now, I understand what you're saying, and it doesn't matter how it's written, but it takes out the fact that we, as an educational school district, recognize a group of students. that are transgender. And it's 1% or 2%, but it takes out that idea that we are not gonna let anybody discriminate against any student in this district. And that's why I understand what you're saying, but because we have kids that need it.
We all have our, yeah. We all have our opinions.
That doesn't seem transgender, good gender period.
Language doesn't say trans.
You know, I'm gonna vote in favor of this amendment as well. I think that whether that language is in there or not, I think that for us to go against what is stated in the law and define sex, I don't think that's appropriate to do at our level. And the legal system catches up with all this activity, I think that we need to be clear on following what the Constitution says and have it go through that process. I will say, though, that whether that language is in there or not, students that are transgender in our community will not be discriminated against being admitted to our school, taking classes, doing programming. And like the attorney said, each one of those things is going to be by a case-by-case basis. And if there is, you know, I would propose there are bullying and possible discrimination all over our district all the time, and none of it is acceptable. And so we would still do our due diligence to make sure that kids are protected and not discriminated against. So I don't think this says that we will discriminate against them by not having that in there. So I'll be voting yes.
And we already do have students that identify differently, and we honor that. I mean, with them following our parental bill of rights and getting the parents involved. So yeah, I definitely feel that we are holding up the non-discrimination of all students.
And I would also add that I think it's, you know, when we adopted the Parents' Bill of Rights, we just scratched the surface when you're talking about Bob, you know, the Parents' Bill of Rights said if you register a student with a name and a gender, that is what we would uphold. But it sounds like there's lots of other parameters that we need to make sure that we have in there. So I think after this, I think we need to work with our administration and give clear guidance to how those situations are going to be handled, and that everybody in the community, our school community, knows how to handle that when a student does come forward as well.
I would just like to echo that. I think the chain of custody has to be clear from the board level about the parental rights. And I think we're on the start of that. I think we need to elaborate and spend some more time at the board level trying to declare that so that we don't lose a chain of custody.
Any other discussion?
I'd like to know if we have unlawful in there, because, I mean, it makes it sort of a different in kind in a way, because if we say unlawful discrimination, it then becomes illegal. It becomes a very legal document. Whereas with it out, I think there's a call for an ethical and moral higher level here. And I guess I would weigh in on the moral level and say, you know, not try to qualify with the unlawful. And just, and you know, I do think the policy, you know, is redundant in a sense, but for emphasis, the last sentence being the policy is intended to support and promote non-discriminatory practices in all district and school activities, particularly in the following areas. And I think, boy, it may not cover every base, but it covers every base that I can think of.
So are you for or against putting unlawful? I'm
against putting unlawful.
Oh, okay.
Yeah. I know the lawyer. The lawyer likes that, but the lawyer's a lawyer, you know.
Yeah.
And I think that we're more than that.
What do you guys think on that?
I mean, to me, I don't think it makes much of a difference.
I can change my friendly amendment to just the exclusion of and not putting the unlawful in.
I think, well, my opinion is I was really, I really enjoyed the conversation we had with him today.
Yeah.
And I think, like Biff said, it was quite an eye-opening experience to be able to talk to the lawyer the way that it happened. And I did like his input and his objectiveness and how he spoke.
Okay.
So I really do enjoy how he added that. So I'm not saying he's right or wrong, but I did like it. So that's fine.
I'd prefer it to be in there.
Okay, so I'll keep it in in my friendly amendment.
Any other discussion?
Yeah, I have just another quick comment on, is it possible to amend the motion to include the other policies that we've tabled, or do we have to go by these one by one?
To make similar adjustments.
Well, they all have the same language in them, so what you're saying
Just
is,
change that specific
Any-
language in all, any and all, except for the employment one.
Or we could use it as the arrows of missions for the superintendent to make changes among other policy.
yes, Chris,
Procedurally, the motion was for policy 2260.
Okay.
So you would have to go back. You would have to rescind your amendment. You would then have to rescind the motion. You would then have to move to look at policy 2260, policy 2266, and policy 2521, so that the motion encompassed all of them. That would be procedurally how you do it.
It would be?
That would be procedurally how you do it.
Okay.
Okay. Well, in that case.
so you're better off doing this one, and if you want to
And then
group
group
the
the
other
other
two together.
Okay.
And then make it the same.
And
word.
then Lori would like that too, because it'd make her life easier.
She's been typing away like mad.
Is
Okay,
that okay?
that's fine.
Yeah, I just have one question. Why is this important? You know, why is this important that we eliminate the extra verbiage, as you see?
I think it's important that we stick to what the statute says.
To me, it's just a gray area that I'd like to avoid. I mean,
Correct.
again, I brought up Sumter a few times. 18-year-old man brings his pants down in front of 14-year-old girls.
And until the
I don't
government,
think that,
I'd like to avoid that.
well, I don't
that's a
think
reasonable position.
doing this would avoid that.
I think it kind of eliminates the gray area if our policy is kind of unclear and vague and could be read in a way that someone might interpret that, hey, I could just
Well, it's
do
inclusive.
that, or they're
It's
discriminating.
certainly
against me.
inclusive.
it
I
is
don't
a
know if
gray,
it's-
it is a
Yeah,
gray.
I just think it's
We
a
all know
gray
it's a gray area because we're arguing about it, right? So, but what I'm thinking,
Yeah, but I'm wondering why we are. I mean, I don't
That's
see
why-
it as particularly
Okay,
vague.
let's,
I guess that's why I say if you stick to exactly and letting legislature and letting courts go through and let them separate what's gray and what's not, that's fine, and we'll deal with it at that point in time. But as of right now, they've given us a set verbiage, and that's where I'm sticking.
And further, even the WASB guy, or the attorney, Bob, said that their policies have it as an option. So there's other reputable firms that
correct.
don't include it, and there's other districts that don't include it, so it's not
Sure, I
like,
mean, the courts are gonna decide on case law anyway, not on this.
Eventually, they will, right?
Yeah,
Carrie, I would say, one of the reasons why I think it's important is because it has become a political football. And it's deviated from the intention of what Title IX was originally set out to be. And what I mean by political football is, you know, in 2017, Obama did this, then Trump did this, then Biden did this. And it's become this political football. And it has been cloudy on what it was really intended to be. And so if we go back to exactly what the statute says and the language and the verbiage that it uses, and we allow the court and the government and our Congress and all the checks and balances, not one president or the other, or DPI or the Department of Education to interpret and to tell us
we're gonna do that.
what the meaning is. I think that we need to let the system catch up with what is going on, and in the meantime, stick to what the cut and dry Title IX is. And it specifically says sex, there is no definition for that, and let case law with all the individual
so
Federal law doesn't say
nuances,
unlawful.
nuances of it.
Case,
So Title IX
Title IX doesn't say unlawful.
is supposed to get us away from discriminating because of sex. It's supposed to move us beyond that, correct?
And sex has become
Okay.
kind of
And
complicated.
yet,
Yeah.
and yet, I'm not sure we can define what sex is. Is there just male? Is there just female? If you know DNA and you know the way people are formed, there are not specific males and females. Sometimes there's more X's, sometimes there's more Y's. And I think the spirit of Title IX was, we're not going to discriminate against anybody. As the 14th Amendment says, we should not discriminate against anybody. And yet, we don't have the courage to put in a sentence about kids who might not know yet if they're male or female. We don't want to use the word trans in a document. He did not say, when he was talking about policies, I wrote it down. He said, if you put it within your policy, the courts are still deciding it. But he said, in your policy is better. That's what I heard from him.
Did you?
Because you must follow that policy, whether it's in there or not. You're going to have to do that, or somebody's going to say you're discriminating.
Well, that's exactly why I think we should leave it out.
And that's why I think we should leave it in. Because if we leave it in, our policy says we shouldn't be doing it. You're saying take it out. Well, it's not going to be in there, and somebody's going to say it's not even in their policy, we're doing it.
Well, if we leave it in there and then a male wants to unrobe in front of a girl in the locker room, they could say we're discriminating.
You missed the most important thing he talked about, Tony, is you come up with situations where you work with the staff in the school not to let that happen. It happened in Sun Prairie because they didn't supervise a locker room.
Look, we're talking about penises in girls' locker rooms, dude. It's not that freaking complicated. I don't want it, okay?
I don't either, but the solution isn't leaving this out. You think I want that, Tony?
You're defending language.
I'm defending a group of people who need to be defended.
Everyone's for defending these people. I'm just trying to be reasonable about how we approach it.
And we still are defending it. We definitely,
We're just not gonna talk about it. We're not gonna say they exist. Yeah.
I don't think
saying
it's
that at all.
that. I
That's
think
okay.
if
Call the
we
vote.
say that we define it and include gender identity in here, then everything below here is extracurricular activities, which means sports, which means co-curriculars, library, media, instruction, on and on and on. So we're taking a stance and we're saying that we have decided that our definition of sex includes that, and therefore those that identify, males that identify as females, they can be in any one of our curricular activities, including sports, and be on a female sports team. And that is not something that I'm willing to support. And again, I will say it again. You say that we're afraid to put this language in. It's not a fear of taking a stance. Again, no kid should be discriminated against based on their gender identity when they walk into our building. However, if this is in there right now, there is no reason why a student, if it's in there, that they can't come in tomorrow and say that I want to use that bathroom and I'm a transgender female and I want to use the woman's bathroom. There is nothing that says that they can't do that right now.
And we
because
can
of the
say
way
no.
that
We can say no.
and that would be considered discrimination.
And
they
then
would
let the
fight that
courts,
argument.
and then let the courts sort it out. Because we have that ability to say no. And he explained that, and there's ways to work that out.
but if it's in your policy and you say no, then you're kind of contradicting.
Can I talk?
Yeah.
Go ahead.
I want to highlight the testimonial that Mr. Trask gave us as well about gender dysphoria. I think we're trying to throw out the baby with the bathwater here. Gender dysphoria is a real thing. And some people identify in it before they're minors, and then they go back to their biological sex before they turn 18. So to blanket and say that we have to not say that there's not a gender dysphoria anymore, that you're transitioning, you must be one after you've decided to change. That doesn't make sense. So under the basis that there is gender dysphoria and people do transition back to their
Back and
original
forth, back and
biological sex, I don't want to try to be the judge, jury, and executor before a minor turns into an adult.
Correct.
You know, that doesn't make any
That's-
sense.
that's
Why
right.
would we be trying to create something when there is empirical data that people detransition before they're 18
Absolutely.
successfully, and they don't become sterile, and can't have children.
Sure.
So anyways, I won't get into that, but
Could somebody explain to me the difference between gender status and gender identity?
It's changing every day, dude. Well, I couldn't tell you.
Well, yeah, I mean, the stuff in parentheses seems to be, doesn't add much, I don't think, because it's kind of undefinable in some ways, I guess. Change of sex, I understand.
thank you.
I agree with
Okay, any further discussion?
So read the motion.
Was an amendment to exclude that language that's within the parentheses and to add the word unlawful prior to the word discrimination.
Unlawfully discriminate on the basis of race, color, religion, national origin, ancestry, creed, pregnancy, marital status, parental status, sexual orientation, sex, or physical, mental, emotional, or learning disability. And that you're keeping the protected classes in there, correct?
Yeah.
Yeah, that's just,
Yes. And the rest goes on as stated.
Is that correct? Correct. Okay, all those in favor say aye. Aye. Any opposed?
No.
I don't know, I'm gonna abstain. I guess I'll vote against it because of I don't like to unlawful. Since, you know, you made the argument that you wanted pure statutory, so, you know. I think that changes the mood of it. But
Thanks, Gary. Okay, and then, so does anyone want to bring up policy 2260?
26.
You just
I'm
amended
sorry,
the policy as
2266.
approved.
Right.
Oh, okay,
Sorry.
thank you.
Didn't mean to be rude. I heard you clear your throat.
Thank you. Okay, so we voted to agree on the amendment, and now we are going to vote on the policy for the first read with the amended language.
Correct.
So all those in favor say aye.
Aye.
Aye. Any opposed?
No.
Carrie?
Okay. I already said aye.
I'll just abstain, yeah.
Okay, abstain from the second one, okay. All right, okay, so now we're looking at policy 2266.
Yeah.
And do we have any motion on,
I would like to
Action
motion to
on
make that amendment to include that very same language and replace it from what is in there. That makes sense?
Just says on the basis of sex, parentheses, including sexual orientation and gender identity.
Correct. Do the same changes.
But we don't need, do we need, I mean, it's discrimination on the basis of sex is the topic sentence there. You know, that's it's what identifies the policy. So we don't need, you know, ancestry, creed, et cetera, right?
Well,
I think we just
I don't want
says,
to try to screw up what Lori was putting in there, but
I think because it focuses on the language in this one refers to Title IX, and so they're using Title IX in that language.
correct.
So we're talking about the first paragraph here in this one.
I don't,
Okay, all it says is, the board does not discriminate on the basis of sex in its educational programs activities. So Carrie's right, it doesn't need all of that.
Okay, as is required by Title
I mean,
IX. then.
it's-
I guess that's kind of in there. Are we all in agreement on that? Okay. We don't even have to touch
but it
that.
doesn't, the topic,
No, it's not.
non-discrimination on the basis of sex doesn't say, and ancestry,
I don't
et cetera,
have
et
it.
cetera.
Oh, I'm looking at the current one. Is that in our,
Go to the new one.
oh, the new one? Okay.
66 introduction.
Yeah, 2266, yeah.
Okay, so you're making a motion.
I think it
This
just
is
leave
where
it
it
the
is
same.
here.
Right. Now we just remove the words inside the parentheses and add the unlawful prior to discriminate.
Where's that in on this one?
Oh, God.
It's.
I don't
it's
know.
down there, it's right here.
It's the very first paragraph.
Yes, the very first
Yeah,
sentence.
so
Very
remove
first
the,
paragraph.
I make an amendment that we remove the parentheses words and add unlawfully before the word discriminate. Looking for a second.
I'll second that.
Okay, seconded by Tony.
Carrie, would you vote yes?
No, I'll vote no on this one, because this one's purely about sex, and the parentheses is simply a way of, huh?
I don't think that's how you meant that sentence.
No, I didn't mean it the way you took it, but,
Well, right.
but it clarifies the dimensions of, on the basis of sex. It defines it, it expands it to include sexual orientation and gender identity.
Well, there's, the reason why I would say to change it in this one is because this one is covered under Wisconsin statute 118019, which is the health and development classes and things like that. And it actually states in there,
What?
in 1M section B,
Okay,
that it has to be medically accurate. And then it defines what medically accurate is. It actually states in 119, let's see where that's exactly at.
I don't know, what's it cost?
But anyway, it states that it has to be, medically accurate and published in journals and reviewed by peers and everything else. But, so there's a long way to go before that ever gets through
I
there.
don't know.
That's why that's.
I think you're kind of trying to restrict who's protected here.
Well, right here, it states in there medically accurate information means information that is scientifically based and published where appropriate in peer-reviewed journals and textbooks. That's the law.
I don't care.
Well, that's the law. You don't have to care.
Yeah, yeah.
That's actually in Wisconsin State Legislature.
Okay.
Okay.
Okay, so we have a motion, a second, any discussion? Besides that?
We have a second, right.
Second. Okay, all those in favor say aye.
Aye.
Any opposed?
No.
Okay, and then we have, the second reading of,
We have to make a motion.
oh, sorry. Gosh,
Motion
thank you.
approved.
Appreciate it.
Second reading.
Make a motion by Spalding,
I'll second.
seconded by Tony. All those in favor say aye.
All right.
Aye. Any opposed?
No.
Carrie? Okay, and then the second read of policy 2521, and this is the selection of instructional materials and equipment.
Was that, Casey?
This is 25,
That was the second reading.
521, and it was in its second read.
5 paragraphs.
Paragraph?
So what do you want to do?
It says including.
252101 or just 2521?
2521.
Or gender.
Oh, yeah. Yes.
They're in board book. In board book.
Right.
Yeah, I'll make the motion to make the same changes. So 5th paragraph, we'd add unlawfully in front of discriminate, and then strike the including gender status, change of sex, or gender identity language.
A second.
Okay, any discussion on that?
You
I second.
Yeah.
All right.
Okay, all those in favor say aye.
All right.
Aye. Any opposed?
No, I guess not. Yeah.
Okay, and then
Motion to approve?
motion to approve by Spalding, seconded,
I'll second.
second by Tony. Okay, all those in favor or any further discussion? Okay, all those in favor say aye. Aye. Any opposed?
No. No.
Okay.
I just don't see what difference.
Okay, so just a couple meeting dates to remember. We have our regular board meeting coming up on Tuesday. And then our special board meeting, where we'll be talking about the CISA 10 facilities assessment. That'll be on March 21st. Same times as always, 6 o'clock. And I think that's it. Anything else? Okay, I'm looking for a motion to adjourn.
Motion adjourned.
Okay,
Pretty
is there a second?
Second.
Second, okay. All those in favor say aye.
Aye.
Any opposed?
No.
Since I voted no. Trying to score 100 on that one.
Yeah, really. It's totally negative, aren't you? Yeah.
You better change your sign, and after all, you better put an asterisk for people that you don't like.
I'm non-binary, how trans and offensive.
I don't think it's gonna make a bit of difference.
I just think my area is not worth it.